Good morning, good morning, good morning, everybody. Good morning. Good morning, good morning, good morning. All right, guys. Oh, God, I see y'all already talking about it. So let me tell y'all where we are at in the tussle. There's a little bit of back and forth between me and the powers that be, but I will not be Mrs. Love. Okay. Um, so like I said, I was made aware about 6 weeks ago that what was referred to as LawTube was like under. Okay. Um, so I was made aware by two other content creators who I have no idea who they, we didn't like, I didn't watch their channels, but they're way bigger than me. So I have no idea how they got to our little area, but they were like, hey, be careful. This is what's going on. So here's the dealio. Because I have been a little scrappy going back and forth, but I may not continue the back and forth. Okay, so here's the thing. We know that when we started this, we were doing the recaps and watching trial duty recaps, and we said we wanted to watch together. Now, we know that lives lived on other platforms a lot more than I don't do this the way most people do the tube, right? So people, what they want over here is more analysis than court, is what it's looking like. So even though we have constant engagement, constant analysis, constant back and forth, and it's not just watch and get off, there is a push to be not so much court. Watch a little court, talk about what happened. Watch a little court, talk about what happened. So more so like a recap episode or show. So I'm going to be honest, guys. I will do this. I will watch court because the the thing that I do, how you guys met me, right? And I think Montresa, because you got to remember, there was a push at one point where they were like, "Oh, when one thing got shut down, they were like, hey, we're gonna add some gifts. You can do this." Those things never really happen when it comes to lives. So I think over here the lives are like supposed to be sporadic and more so recorded, very intentional, edited sometimes. So can we continue to watch? Absolutely. But if we're going to continue, it looks like where this argument is going is that continuous watching of trial, no matter how much analysis is happening during the trial, the continuous watching of trial is not what they want, is the vibe I'm getting. And if that's happening, okay. That's not, I mean, I'm still gonna watch court every day, but y'all know I use this to do the recaps, right? So I still gotta watch to do my recaps. But the trade-off is if we do it the way that we do it, then that might not be what they want to benefit. I understand that's what people want. I understand from other channels that's what people want, but that I don't think that's what the powers that be is wanting. And I think it turned into a big thing with YSL, and then a lot of that began to happen. So what they want is like we do with WTF, play the clip, talk, play a clip, talk. So it's not as much all of that. You said till dawn. So, but the thing is, I love watching court with you guys. And since, best friend is on the phone, so I can talk about her. It's not really talking behind her back, but I say it to her face, and I'll talk behind her back too. So, I started making the videos because best friend wouldn't let me scream in her ear no more. So she made me make a video. So I do think that we can still watch live, but if we continue to do it this way, we may not be able to have a benefit to the channel, which I'm not mad about. I mean, it's always nice, but the how can I say this? Recorded videos do 10 times better here than a live. Probably 30 times better than a live. So I guess in the realm of being a tuber, I wasn't getting out of it what I should have anyway, or what other people would get out of it. So I don't want y'all to do that. Right. So way more analysis and talk than court. But if you watch all of court, they will, Paula. And from what I understand, because that was a question that I asked, what I understand, if we get to a point where the appeal is up, the appeal is not, it doesn't work or it's not overturned, then whatever portion that I would have gotten for last month, they'll refund you guys. How they want it. I'm still going to watch. You said I want my color. Listen, the green, I was like, dang. So we have to find a way to do. What was that? We also got to call Aunt Jackie. It's Aunt Jackie's birthday. I'm not telling anybody to do anything. What I'm saying is I just got good news yesterday. And I just got good news yesterday. Plus, I'm still analyzing. Plus, so I'm adding things to my plate. I can't say for sure that I'm going to be able to do like a weekly, put this content together and recap, because I recap already, right? But I'm not saying I'm leaving you guys. I'm still like, I still have to watch court so I can do my recaps, right? Yeah, but from my understanding, Chaz, it's not the whole trial. So it would be like we could watch and then do like something in between this and the recaps, like in the middle. So we might be able to pick, like we do for WTF, some of the big things and like recap for the week, or do recap for 6 weeks ago. No, I was being informed about 6 weeks ago that people were saying like, have they reached out to you? Has anybody said anything about your channel or the fact that you watch trial and stuff like that? So that's what I mean about 6 weeks. I didn't get the email till 3 days ago. So Twitch is not out of the question, I don't believe. Somebody has, so back then it was sent to me, Twitch, Patreon, and something else. I just didn't. Now, the sad thing about it is I think it may have happened inadvertently, because I do know a lot of people made the argument, well, all these other channels are doing it, why are you messing with me? So they may have inadvertently said, hey, we'll look over here in these directions. But I don't think anybody did it out of jealousy. I do think it's because I never referred to my channel as LawTube. And so I guess the LawTube community has experienced this. Boom, that's what I needed 3 days ago. Brand. So like I said, if we do not have a benefit to the channel, I am not against still going live, because I'm going to watch trial anyway, because I do my recaps. Like that's I won't say bread and butter, but that's the bread and butter for me. So this was, I'm still going, even if I don't watch on here, I still got to do my recaps, right? The recaps are where I started, where I'm known, and what I do. And watching trial is so that I could have a recap. So what I'm saying is, if it turns out that, because I can't say, y'all, I'm not gonna lie, I know they ain't letting up. I can't lie. What I'm saying is I can't commit to editing and putting a show together and all of that. If I could, we'd be still doing court of opinion. I can't say I have time, especially with the addition of yesterday. So that doesn't mean I can't go live though. You know what I mean? Like it's just not a channel benefiting live. Y'all got it? Okay. Best friend, I got my glasses on, so best friend is like, oh, so that means, but yes, I'm not finishing it out. What I'm saying is through YouTube, there will not be a benefit to the channel for me going live because it's seeming like, and I'm thinking I'm probably gonna get a response probably tomorrow or day after because I sent the rebuttal over yesterday because I actually wanted to depict how I do what we do. So while we were live yesterday and we went on lunch, I actually recorded like the setup, what we're doing, how we're doing it, you guys going back and forth. And so, well, thank you, Nicole. So I'm saying, regardless of what happens, I'm going to be realistic. I am not going to, I ain't doing no editing. I ain't missing no coin either. Okay. I ain't missing no coin at work and stuff like that. And I'm not going to say that I'm going to edit. Plus, I feel like we miss it. I like the part of us going through each part of trial. And if I have to pick and choose parts of trial just for shock factor, awe factor, or
okay. 231.
I don't feel like it's going to be the same. And I don't know that I want to do that, guys.
For the defendant present, the defendant is present as well. Sure.
As long as they don't mess with my recaps, though, okay? So, there you go.
Just need to not spill it.
Oh, thank you. But I don't want to stop watching trial with y'all. Oh, thank you. Good morning. Good morning.
Okay. Lots to cover. Ms. Nestor, I appreciate the email you sent earlier this morning. Should we start with the O'Driscoll interview?
Okay. I would appreciate that, but at this point, we're just trying to take care of StreamYard at this point.
1163, which is the state's motion.
But I'm not going to stop watching trial with you guys, whether or not Twitch is an option, probably.
By docket 1555 and Ms. Nestor's email of this morning. Let me get there with you. And I left both of those.
Oh, thank you.
I'll be right back. You can stay seated. Thank you.
Oh, they're sliding in, ain't there? There's a lot of people. I mean, I already know it looks like a lot of people. Just use my name. If that helps. For Pepsi's, just use my name. I have it as my name or my heading. Yeah. I mean, I can still use StreamYard on Twitch, so I'll have to get used to it. Like I said, I looked into Twitch, into Patreon, but I know this is going to sound crazy or kind of like counterintuitive, but I also like people to be able to just watch, right? I don't want people to have to pay to watch all the time. Like if you want to donate, that is amazing. But if not, if you just want to watch, sometimes like rent, mortgage, electric, and gas hitting the same week. And then you like, I just want to chill, and you got to pay for that too.
Okay,
Like
Ms.
something
Nestor,
to pay when, like
with
I don't.
respect to pages
Yeah,
1 to
we can do this
7,
for right now. Okay,
what's the value in
I'll reevaluate
for
this, and we're
this
not in
action
a
under Rule 106,
rush
title
because
pages
I need a
1 to
couple months to
7,
get used to what yesterday
qualify
brings before I can
explain,
say
put
what
into
I can do.
context the stuff that follows.
Mainly because
Oh,
it
nice,
gives
Amanda.
the reason why.
Thank you for that. I did not know that.
Like
You
what
let
you're
us
doing
choose.
there and why the interview is happening. And
That sounds like a nice way of saying "shut up, Laura."
And I believe that's important to put the whole interview into context. I don't see there's anything at all objectionable in it. And it does provide a context of how this meeting happened. They're not in the police station, they're in her house. She invited him in. She voluntarily met with him. All of that, I think, matters to context, and we're asking that it come in, especially because there's nothing in it that's controversial, and there are things that I think that are very helpful.
Mr. Bloodworth.
Your Honor, there's a distinction between context to the interview and context to particular statements. And while this provides context to the interview, it provides no context to kind of any of the 6 individual statements. The interview context can be sufficiently drawn out through examination of Jeff O'Driscoll. I mean, I'll lay a lot of some of that foundation before I introduce any of the statements, and then of course he's subject to cross on that. The other thing is this is peppered with the defendant's self-serving statements that the state holds the keys to.
Okay. So we're going to do this one chunk at a time. The standard under Rule 106, and it's not discretionary, it's an on or off switch, is whether the portions that, in this case, the defendant wants to add to the designations made by the state are necessary to qualify, explain, or place into context.
Oh, okay, Laura. Gotcha.
Interview transcript that the state.
Yeah, I don't want that to be the feel. I want this to be organic conversation, and this gets me through work.
Cruz Mesa, 2003, Utah 33, at paragraph 14. Here, with respect to pages 1 through 7, I'm persuaded by the state that this context for how the interview occurred
I'm wondering, Nicole,
through direct and cross-examination of Detective O'Driscoll, these 7 pages are not necessary to qualify, explain, or place into context any of Kouri Richins' statements that follow. Okay, so we're not going to add 1 through 7. Those will stay redacted.
Good morning.
Then we get to pages 15 to 16, right, Ms. Nestor?
Yes, sir.
Okay. This is new as of this morning. Give me just a moment. Did you have a specific line number or the whole pages?
Just the redactions that are on both pages, we would like unredacted. So it starts at line 10.
There are no redactions on those pages.
I have redactions on lines 10 through 25 on page 15 and lines 1 through 12 on 16 is the copy I was given.
Your Honor, in negotiating this back in whatever, January, the state conceded to her request to unredact that. The state unredacted.
Maybe I'm too close to us because we had to compare notes. Look at her. We ain't sitting together. Best believe it's because we're trying to get 2 angles at once.
Okay. That's smooth then.
Very good. That brings us to pages 29 to 32.
You said her jaw looks swollen. Damn it, friend. Hold on.
So here we have Ms. Richins making references to Eric going to jail and Cody's involvement in that situation.
He broke the law.
Why is this necessary to qualify, explain, or place into context Ms. Richins' statement.
Kouri said, we all go to jail over
of
here.
the transcript.
One band, one sound.
Give me just 1 second.
Sure.
So previously, they were talking about whether or not
Kouri, is somebody
he was
lumping
happy,
you up?
if he was depressed, if he was suicidal. And as a flow,
The defendant,
of
she
that
had a knot on the top of her
it
head,
then goes into
like a
the
Looney
questioner
Tune
has
buster in the
asked,
head with a
okay,
skillet.
anything else regarding his mental health?
No,
issue?
it should
That's
look like
line
her
3 on
jaw
page
swollen, but I
29.
think it's just her
She
sunk
answers
in
no,
face.
not really. But then she goes into like there wasn't generally,
Really?
meaning he had his struggles, he was stressed, and then she explains how he was stressed. So I think it's or why he was stressed about his relationship with his business partner. I do think that completes.
Why around her eyes look dark? Or
Yes,
maybe
it's
she
a
tried some
question.
eyeshadow. What?
Completes the
Kouri.
entire subject matter of the conversation.
Maybe the blush is going straight back.
Actually evidence
Or
that
the
has already
what is
come
that?
in as far as no longer being objectionable. This all came in Cody's testimony. So we would ask that it be put back in.
So I think you have
I was about to say, is her eyes black?
fairly characterized everything through page 30.
Cameraman trying to see what I'm seeing. I'm on it.
After that, though, I think he turns in a different direction. That is not relevant or does not qualify, explain, or provide context for what you just described.
I really don't care about the rest of it. If
Mr.
you-
Bloodworth,
Because I knew that wasn't Cody.
line 29, page 29, line 5 through page 31, line 3.
So we will unredact that portion. Your Honor.
I think it's a fair continuation
Fair.
of Kouri's explanation regarding things that were stressing Eric Richins.
Yes.
Okay, very good. So we're going to unredact page 29, line 5 through 31, line 3. The remainder of that redaction stays as is.
Judge all up in that thing. Very intuitive. Part of every process. Listen to every word. Correct quotes.
107 to 112.
And make everybody stand on legal business.
Help me out, Ms. Nestor. I wasn't quite following defendant's position on this.
Okay, just 1 second, Your Honor. I'm sorry. So this, and it's getting hard for me to remember what I know from what happened in the courtroom versus what I know from getting ready for trial. So I apologize. I cannot remember if this came in yet. I think it's going to come in with Mr. O'Driscoll if it hasn't already with Chelsea, but there's conversations in here about texts with Chelsea on the day that Eric passed. And it's a continuation of O'Driscoll asking about phone records and him reviewing available phone records. And she goes into what she's reviewed in terms of the calls between her and Chelsea. So I do think it's all part of one conversation. Let's see. And I think to the extent that hasn't come in yet, I think it's going to come in today.
Well, I don't disagree with your prediction about what Detective O'Driscoll might testify to. The task I have to engage with here is whether any portion of 107 through 112, line 9, is necessary to qualify, explain, or place into context Ms. Richins' other statements in this interview.
So I think it's a direct continuation of the questioning above it about telephone records and whether
Right.
she has available phone records, and she discusses these records of calls with Chelsea. So I do think it's all one conversation.
Can you point me to specifically? It seems to me that in the preceding pages, they're talking about what phones she had access to during what periods of time, when those devices were or were not available to her, which belonged to C&E, which belonged to her.
If you go back just a little further, Your Honor, to page 105, line 15, Detective O'Driscoll starts with, okay, so when was the
Hold on real quick. It's on Jackie.
last time before the night of the 3rd that you talked to Chelsea? Do you think it was the 2nd? And she says, I think it was the 2nd. And he says, when you guys were talking about the anniversary, do you know for sure if it was the 2nd or 3rd? Kouri goes into, well, yeah, because actually she sent me all the text messages because they were saying Woody tried to tell Chelsea, which was not true, that Chelsea's the last person I talked to. That's absolutely not true. And that there was some kind of message or something the night of the 3rd. I don't know, but we've pulled all phone records and Chelsea still has messages on her phone. So none of that is accurate. And then it goes into, do you have those records? They were talking about subpoenas. Do you still have them? And then they start redacting her explanation of how she got these texts and basically that she's looked at them and what they say. So I think you're cutting out the second half of that conversation, which to us is misleading, and we'd like it all in.
Your Honor, may I offer a suggestion?
Yeah.
The state proposes to redact page 105, line 15, all the way down through 107, line 11. So redact the entire portion as it relates to Chelsea Barney.
Okay. That removes the necessity of what follows, Ms. Richins. Ms. Nestor.
It does, except that I think they'd have to go back further because they still have up there where Detective O'Driscoll's basically saying it's weird that your conversations with Chelsea's are deleted. So, I mean, they're just picking the part they like and taking out all the rest of it, right? So they'd have to go back further. If they really want to take out everything about this, it would eliminate my objection, but they'd have to go back to, let's see.
So why don't we go up to 105, line 3?
Okay, let me look at that.
The state still gets the general question on page 104 into 105. It just doesn't focus on Chelsea.
That would fix my objection because then it would just take all of it out.
Well, you're,
For example, just so the record is clear, because we only have an audio record here,
Sure.
we have Detective O'Driscoll asking about whether is it possible that things were deleted on your phone? And Ms. Richins saying at 104, line 20, yeah, that's just not possible.
Right. Right. And then he gets into Chelsea starting on page 105. So, right. If they would delete from 3 of 105 all through all of it, then that eliminates my objection because then they're not just putting in half of it, not the other half. But I would withdraw my objection under those circumstances. But if they want half of it in, I want all of it in.
well, okay, Your Honor, I think we're narrowing in on this, but I don't think we're there yet.
Okay.
I think the defendant raises Chelsea, right, at page 105, line 8. It wasn't Detective O'Driscoll. So I think the redactions should begin
Oh, I see your point.
at
Line 15.
line, right.
She's using recovery of information on Chelsea's phone as an explanation for why she wouldn't bother to delete anything.
Correct.
Okay.
And I think
So-
there's a distinction between, right here, I think at line 15 is the tipping point where there is a statement about deletions.
Right.
And then at line 15, it tips into a discussion about text messages with Chelsea in particular.
That's fine, Your Honor, if you want to start at line 15.
Okay, so we will add the following redactions. We will redact line 105, sorry, page 105, line 15 through 107, line 11. And that resolves defendant's request to unredact pages 107 through 112, line 9. Scott, I went kind of fast there. Did you get that?
Yes, Your Honor, we have someone else listening. in as
Okay,
well.
very good. All right. Anything further on that, Mr. Glover?
No, sir.
All right. $15 through 107, line 11. All right. That brings us to page 120. Line 24. To 121, line 8. This is Kouri Richins giving Chelsea's phone number to Detective O'Driscoll. I didn't follow how this relates to a prior statement.
Just one second, Your Honor, I'm sorry. So all this stuff above that is redacted, right? Are you looking at it?
Yeah.
Okay, just a minute, I'm trying to. Twenty-four through line 121, line 8. I'm sorry, I'm getting a little bit lost. Just give me, let me,
No
look
problem.
at, let me look at my notes that I did just one more time. So right now we're looking at the 120, line 24 through 121, line 8.
Please.
Okay, I got it. Just one second. This may not apply anymore now that Chelsea's testified, but let me just make sure. We'll withdraw that one, Your Honor.
Okay. Then let's go to page 125, lines 6 through 16.
Y'all are showing out. Thank you, Laura.
I don't know why defendant wants to unredact this. This, we have worked real hard. to get
Thank
this.
you. Oh, I think Kouri is the real culprit here and has tried to convince
Then
people.
we go to page 133.
There is a lot of people out there, Nicole, that believe that Eric had a problem.
Looking at line
I went on X last night and I went on watched a couple videos on TikTok, like after I did my recaps where
My
people were
notes
in there,
reflect that this is a discussion
their
regarding law
explanation of what they
enforcement
think is
officers
going on.
Kouri Wright, taking all computers related to C&E and maybe some others, and Cody having access to the garage and
Is it?
office
Sorry.
at the Richins home. How does this provide context for Ms. Richins' other statements in the interview?
Just a minute, I'm trying to see where their redactions start and end on either side. So give me one second. 106. So is everything after 141 redacted still on the
Unlike any I've ever seen.
Everything after 141 is redacted still.
No, there's some unredacted portions beginning at page 167. The statement before this redaction that we're discussing is the defendant's statements as it relates to life insurance. The statement after this redacted portion we're discussing is the defendant's statements as it relates to the trust. And the piece that we're redacting relates to a collection of C&E computers, which in the state's view under 106 is not context to either the preceding or the subsequent statement.
133, line 12 to 140. That looks accurate based on my review, Ms. Nestor.
I think most of this has come in now, so I'm just making sure that there's nothing. Almost there. One more second.
Take your time.
It was quite a few pages. That's all come in, Your Honor. We don't need it anymore.
All right. So defendant's request to add pages 133, line 12 to 141 is withdrawn. Then we fast forward to pages 174 through 184. Here, Ms. Richins is talking about the party's joint account and the flow of money from C&E and her real estate business through various accounts.
Tiffany is always calling me by my first name.
Right.
The immediately preceding statement is regarding the trust. The immediately following colloquy seems to be about life insurance policies.
Yeah, just a minute. So this is 10 pages. I also think most of this has come in. If you can give me just a moment, Your Honor.
Sure.
Ooh, Paula. I was wondering about that. Why? Because it still sticks out to me because I know I do it sometimes. Look at me admitting stuff allegedly. But sometimes, like I said, Big Unc will swipe his card and walk off and say, oh, just hand it to my wife. Just hand it to my wife. Or don't let him be at a doctor's office or something and did not fill out the paperwork. Or I'll do his, like, the doctor's office to say, hey, fill this out now on the portal, or when you come in, you have to do it. I don't want him calling me the whole time he at the doctor's office, so I just do his portal stuff online before he go. He just got to sign it. Or I'll fill out his paperwork and let him sign it. Like I do that a lot. So
Page 213.
by them saying that, yes, it might be commonplace, but
through through
They might have screwed her
215,
over as far as signing
line
shit for the
6.
next trial.
This
Like you
immediately
said.
follows a statement by Ms. Richins regarding Eric knowing about the HELOC and consulting a divorce attorney, and him knowing about that based upon statements made by his family members. I'm not sure.
I don't think they ever
Forgive
left
me.
her ass.
I misstated that. It immediately follows a statement by him about knowing about the HELOC. And then Ms. Richins talks about how he knew about that was because his family members told him, and then he went and consulted with a divorce attorney.
Right. I do think that's all one conversation, Your Honor. Where they're talking about how he, I gotta go back a little further. They're trying to say what they're accusing her of and how they changed I mean, that's all one conversation, I think. I stand on that
Tell
request.
me why Ms. Richins doesn't pivot away from what Eric knew to what his family members were doing to her. There seems to be two different topics here.
I think she said she met him in college. Remember that little third person story she
Well,
wrote?
I think this is all connected to the HELOC. I mean, Ms. Benson testified early on in this case that the HELOC was what precipitated the meeting with the divorce attorney. The divorce attorney has also testified to that.
Right.
This is Kouri lumping all that together in one
Oh,
conversation
excuse
with
me.
Driscoll. So I do think this all should come in context. I just think it's all connected to the beginning of the conversation where they're saying that he was unhappy about the HELOC and that he had been meeting with someone about a divorce and that Kouri was unaware of that and that she learned about that later from the family. So I think that's all connected. I would ask that come back in.
Mr. Bloodworth.
Your Honor, the preceding statement, which is the statement the state seeks to isolate, is the defendant's statement regarding what she knew about the HELOC. In the redacted portion, she then pivots to divorce attorney discussion, which is in her statement separate and distinct from the HELOC discussion. It has come out in trial that the two are connected, but in this statement, it is a distinct statement through the course of this interview.
Just in terms of ending that, Kouri Richins. Yeah, I think it seems that Ms. Richins' sentence that begins on 213, line 22, doesn't actually end until 214, line 2. It looks like maybe she and Detective O'Driscoll talked over each other in that point. It would seem appropriate to end it there and then redact the rest. So just to unredact 213, line 25 through 214, line 3.
Agreeable.
Okay. That's the court's ruling, Ms. Nestor.
Understood.
So we're going to unredact page 213, line 25 through 214, line 3. Okay. I think that handles the parties' positions regarding the transcript of Detective O'Driscoll's interview with Ms. Richins. Mr. Bloodworth, anything else on that?
No, Your Honor.
Ms. Nestor?
No, sir.
Okay. So that brings us to the jail calls. This was originally filed as docket 1165 by the state. It's further characterized by docket 1555. We're just going to have to go through these one at a time. As a matter of mechanics, Mr. Bloodworth, these will come in through Detective O'Driscoll.
Yes, Your Honor, as a matter of mechanics, and I don't know at this point if we're going to introduce them all through Detective O'Driscoll on direct. In fact, trying to recall, there may be only one or two that I can pin down that we may want to address first, although I think that if we can, we should resolve the whole set of them today, because I can see how it would come up in either redirects or some crosses that would begin,
Okay.
could begin as early as today.
All right, let's go through them. So tab, well, I don't know if you have the same binder. Let's go 2-69.
That poor Jay just sitting back there.
Your Honor.
And my main concern is on page 8, lines 6 through 18,
Sorry, Your Honor, I'm just pulling it up. Which one are you looking at? Can you give me the number again, sir?
2-69T.
Okay, got it. And what portion are we looking at?
Well, the court's concern, based upon the content of the unredacted portions that the state seeks to admit, is page 8,
Lines 9 and 10.
especially. Yeah. Although,
Well, that's definitely part of it. Well, that's Carmen being in jail, right?
yeah,
No, she's not in here, meaning Summit County Jail.
Jail is she in because she's not here?
yeah.
Oh, well, she's not
The only
here.
way was Ms. Richins would know she's
Right.
not there is because
Right.
she's there.
Right. Yes.
So yeah, Your Honor, we can certainly redact line 9 and 10 there. We can even redact 11. I don't,
Yeah, if we
Just
can
to
do
be
9,
safe.
10, and 11. Yeah.
Yeah.
Okay.
She realized Carmen snitched on her.
Ms. Nestor, what was defendant's objection to the remainder of this?
Hold on just a minute, Your Honor.
So Brittany, from 2-69T, we're redacting page 8, lines 9 through 11.
I think that was my objection to this one.
Okay.
Let me just make sure. I think that was it. I think that was the only problem I had with that one.
Very good.
Wait, hold on. That's Carmen. Yeah, that's it, Your Honor. That was my objection.
Very good. Let's go to 2-71R. There's only 3 text messages sent from the jail
Oh, I'm
system.
sorry, Your Honor. Oh, never mind. They redacted it. Okay, I apologize. Please continue.
2-71R. These are text messages sent from the jail system. The state seeks to admit 3, right?
Yes, sir.
It's the ones from May 24 at 9:50, May 24 at 10:02, and May 24 at 10:03.
Correct.
Okay.
So we have a couple of objections to this one, Your Honor. It looks like they have made all the redactions that we requested that indicate it's jail related. So that those have been resolved. However, this is a correspondence between Kouri and her brother. And the brother's asking her, did Eric ever talk about suicide?
Right.
And she's repeating things that Eric said to her, which would be hearsay. Also, I believe the brother's statements are hearsay.
Well, all of the non-Kouri Richins statements are going to be hearsay if they're accepted for the truth of the matter.
Right.
So that's
Well,
an
but
issue.
they're specifically trying to admit what Eric said for the truth of the matter. So that's the concern that I have. She's like double hearsay. I know Kouri's statement isn't hearsay, but when she relays what Eric told her, that is hearsay. So that's our objection to this one. Also, we just don't see the relevance. There's no.
You don't see the relevance of whether Mr. Richins ever spoke about suicide.
I don't think either side is making the allegation that he intentionally killed himself. That's never been said by either side.
I think the state is seeking to prove affirmatively that he did not.
2 messages on your phone.
So I think we can put relevance aside. It's certainly relevant.
Okay.
Mr. Bloodworth, talk to me about the hearsay. Put the brothers level aside. It's the truth of Eric's statements to Kouri as related by Kouri. Kouri's level, categorically not hearsay. It's the Eric Richins level. Let me pose a hypothetical to tease out the legal issue. It'd be one thing if, I guess what we're trying to tease out is whether this is evidence of whether Kouri ever heard Eric say it versus whether Eric ever had suicidal ideations.
So I appreciate that distinction, Your Honor. She doesn't quote him, right? It's a generic, this is my impression of generally.
Of my husband.
Right.
Yeah.
Well, respectfully, I disagree. He would always say things like, if anything ever happened to me, blah, blah, blah. I mean, if they want to redact everything after the word not suicide specifically, then my objection, apart from the relevance, which I stand by, but that would cure the hearsay problem. What he actually said. But they could leave in her answer not suicide specifically, because I don't think that relates to a particular statement. It actually refers to the absence of statements.
I think the opposite. That is what explains her statement, not suicide specifically.
Well, then it shouldn't. Then none of it should come in.
Right. The statement is Kouri Richins' statement is not suicide specifically. The remainder of that particular text message is, in a sense, 106 completeness, because she is explaining her statement.
Why don't we just instruct the jury that they can't accept Ronnie or Eric's statements for the truth, but they can accept them for the effect they had upon Kouri Richins and let the whole statement in?
Correct, Your Honor. That's appropriate.
Because it's not being offered to show any effect on Kouri Richins. It's being offered to get in the fact that Eric made that statement to her. That's the whole reason this is coming in. And I stand by my objection, Your Honor.
And just to be clear, you don't want to admit the statement that Eric told her they'd be set for life if he died.
No.
Okay. All right.
That's like, no.
Yeah, I guess if the statement Eric made isn't true, what relevance does it have, Mr. Bloodworth?
It explains Kouri Richins' statement, not suicide specifically. It is the effect on Kouri Richins to make this, to respond to the question of, did Eric ever, whatever the question is, hold on. did Eric ever talk about suicide? She says not specifically, and then explains herself.
So
That's
is the
foundation for her statement. It shows what the effect of Eric's statements on her.
right? But as we tease this out, it seems that to the extent that the effect upon her was relevant, regardless of whether it was true, it was her understanding that she'd be set for life if he died, not whether or not he had suicidal ideation. Is that fair?
Your Honor, the state thinks it's both, actually. It is the second he died. It's certainly that, right? But it's also the suicidal ideation part because, evidence will come in that I think evidence is going to come in that she never believed, she said he would not commit suicide in other portions of it.
And at her level, that can come in, right?
Sure, but there's a foundation for that. Why do you believe that?
I think with respect to this particular text exchange, first of all, I don't understand why we need the third one.
Come on, Judge. Make it plain. Trim the fat.
Why do we
Because
need
this is getting ridiculous.
They're saying, just curious. Someone threw out a scenario, made me think. That seems to be a throwaway.
Well, I guess it all depends on whether or not DJ testifies.
Forgive me.
That that statement could be used in impeachment of DJ Kouri if he were to testify.
Is this one of the things that's coming in through the state's case in chief?
Well, we're going to impeach him, Jesus.
Or through cross? My apologies. As yet unclear.
So, yes, Your Honor, let me perhaps resolve, I think, the current tension.
Yeah.
If it comes in the state's case in chief, then I would agree that third statement we could redact. We may have a discussion down the road about unredacting it.
Understood. Okay. So focusing on the first two, I think the correct result here, let me state it and then let counsel ask for any clarification, is to admit the first two text messages with the following instruction to the jury, that they cannot consider Ronnie's statements for the truth of the matter only for the context that they had or the effect they had upon Ms. Richins as the listener. They cannot consider Ms. Richins relating what Eric Richins told her for the truth of whether he ever had suicidal ideations or whether she would actually be set for life if he ever died, but can consider it for the effect that that statement by Eric Richins had upon her on a going forward basis.
What, can we just get a statement as to what effect that did have on her? Because I don't understand that argument at all. And
She
maybe
thought she would be set for life if he died.
Like I was about to say, what are you missing? What are you freaking missing?
Mr. Bloodworth, any clarification?
No, Your Honor.
Okay. Any other clarification, Ms. Nestor?
No, sir. We just would like a continuing objection to that one.
I don't know what you mean by that.
So I don't have to, when they admit it, I won't have to jump up. I just like,
And you don't, under
Okay.
Rule 103, have we discussed anything further on that?
no, sir.
Okay. Scott,
Yes, Your Honor.
would you initially redact the message from Ronnie at 5:24 at 10:03? Just curious. I watched something,
That's-
etc.
I think it's from DJ.
Oh, I'm sorry. You're right. That's from DJ. for now. And I can pause for a second if my description was inappropriate.
Kathy, you ain't the only one. Because I'll be needing attention. I'll be just took them people oxygen mask and put it on myself.
We're getting it. We're tracking it in the back as
No
well.
problem. Sounds good. Okay, moving on. That brings us to 272R. As I understand it, it's 5 text messages from 5/31/2023 at 7:14 to 5/31/2023 at 7:24. I think the relevant part of this, Mr. Bloodworth, is that Ms. Richins saying she hardly knew Hayden Jeffs. Is that the point of this?
Correct.
Okay. And so do we need anything after the 5:31 at 7:22 where she says that?
So you're referring to the last two of those texts?
Yeah.
We can redact those.
Okay.
Wait, I'm sorry, which ones? I missed which ones you're talking about right then.
Another one wanting their 15 minutes of fame. Oh God, huh?
I would object to that coming out. I object to this whole thing coming in, but if it comes in, they should all be in.
All right. Tell me why you object.
I don't understand the relevance of this at all.
So we have testimony that's come out that Kouri Richins had a telephone conversation with Hayden Jeffs regarding the topic of fentanyl. Here she's saying she hardly knew him. It's probative of their relationship.
They don't talk about that at all in here, though, about any conversation that
But
she had with
she
him.
talks about hardly knowing him.
Your Honor, we just stand on a relevance objection.
Okay. Anything else?
No.
Okay. This is relevant to Ms. Richins' knowledge of or disclaiming knowledge of Hayden Jeffs. And do you want the whole thing, Ms. Nestor?
Yes, I do.
All right. We'll leave it as is, Mr. Bloodworth.
Yes, sir.
Okay. All right. Tab 7. Sorry. 273T and 274T and 275T. Mr. Bloodworth, Ms. Shervanek, I am genuinely confused by these in terms of this transaction in St. George and this other deed. And I read them 3 times. I really don't know what they're talking about.
So let me propose this as the way forward.
Yeah.
To date, nothing has come in where the state would use these. I can see a circumstance where the defendant's mother would testify that the state would want to use these texts in the impeachment
Or the phone conversation.
or the phone
Right.
conversation.
Okay.
So maybe we can just put a pin in these till if and when that circumstance arises.
I appreciate that. Any objection, Ms. Nestor?
No, Your Honor.
Okay, very good. We will skip 73T, 74T, and 75T.
Uh-oh, looks
now.
like somebody's awake.
Then we go to 2-76T.
Yeah, they're in. Just waiting.
With respect to this one, the defendant objects to redacting lines 2 through 8 on page 7. Under Rule 106, in the court's view, Lisa making a comment about a corrupt police force is not required to be included under Rule 106. But Ms. Richins wondering if Detective O'Driscoll didn't relate part of his conversation with her to the prosecutor, that seems to provide context.
It wasn't the corrupt police force comment I'm interested in, it's Kouri's, so I don't have a problem with that staying redacted.
So I think if we just focus, Mr. Bloodworth, on page 7, lines 4 through 8.
Y'all, oh my goodness. Oh, thank you for lunch.
I
About to
also,
put all this
while
on
looking at that,
on StreamYard. Just
you
keep our
touch
little
on page
little
7,
channel going our way.
line 19 and 20. I think that's Lisa reading the
Nicole, I think Detective O'Driscoll is their last
information. I'm guessing.
witness before
And
Kouri puts on her case.
That's the hearsay the
I think
court's
he's supposed
done
to
in
be the slam
limine
dunk,
on
the home
page,
run.
line 19 and 20.
A little scary.
On page 7, that also, just that one little part needs
A little
to be redacted.
scary. Very
He later told his friend he thought Kouri tried to poison him. That's been kept out.
Well, that part's come in a couple of times. I think it's the sentence before that's the problem. Because that's part of what the state has to prove, right?
Actually, both of
Yeah.
those.
I think they both come in.
Forgive me, have we gotten the detail of
The only thing that's come
ate the
in.
sandwich, broke out in hives, had trouble breathing?
No.
That details come in, I think, in the context of, well, in Ali Staking's testimony about what they were joking about.
Yeah,
I think it's
certainly ate a sandwich, had a reaction. Was she that specific? I genuinely can't remember.
No.
We can, hopefully somebody in the back scrambling right now
Take a look.
to get that portion of the transcript. I also think it's coming in a text message as well.
There's the June text message, right, where Ms. Richins is, I forget who the recipient of that text message is.
Chelsea Barney.
There you go. Is talking about, they're saying I gave him a sandwich on that day. And
Right. It's correct. It's the defendant saying, I was with him when he ate. I gave him the sandwich for lunch. He didn't break out in hives. He didn't use an EpiPen.
that's right. Okay.
The concern I have also is it says he later told his friend, which is Cody or Case, one of
Well,
those.
he doesn't say that, and we've already got testimony that there was a conversation in which he told a group of people that she tried to poison him.
Jokingly.
Well, whatever.
This is referring to telling his friend, because his friend was not at that conversation. His friend would be either Cody or Josh, and that's been suppressed.
Yeah, I don't think that we know to draw that connection, but the jury wouldn't.
I don't think we can risk that, Your Honor. I mean, there's a reason you made that ruling. We should stand behind your ruling.
Who does she think is she talking to?
Let's take this one piece at a time. Mr. Bloodworth, line 7, can we please add in any objection adding back in lines 4 through 8?
All right, page 7,
Page 7,
4
lines
through 8.
Yeah.
No objection to adding that back in.
Okay, so we will remove the
Contempt.
redaction in
If they was gonna put Brian in contempt, she can surely go.
2-76T of page 7, line 4 through 8. Then, Ms. Nestor, what is defendant's request with respect to lines 16 through 20?
Your Honor, all we're asking is at Lisa Darden's statement, which starts at line 16. And then the next question is, when Eric ate the sandwich, he immediately broke out in hives, had trouble breathing. He later told his friend he thought Kouri tried to poison him. We're asking to redact that whole comment of Ms. Darden.
Mr. Bloodworth, the state's response.
Your Honor, I think the just as a some context here. Lisa Darden is reading from, I think, it's the interrogatories in the civil case. That's why she uses the word question. The important part from the state's perspective is Kouri Richins' response there, ridiculous, right? So the preceding paragraph is necessary for the effect on the hearer. I think the court can instruct around any any hearsay problem about considering it for the truth of the matter asserted.
Defendant's request to redact lines 16 through 20 of page 7 of 2-76T is respectfully denied because that information that Eric ate a sandwich, that he broke out hives, had trouble breathing, later told his friend non-specifically who that is, that he thought Kouri tried to poison him, all of that has already come in through other sources of evidence. That will not introduce any new information to the jury if they were to fail to follow the court's instructions.
Nicole, she says she got 11 million in property, okay?
On Kouri Richins, part of these conversations for their truth.
Your Honor, can I just also, while we're just making the record, we would also ask that lines 9 through 13 be redacted on the same grounds. I understand your ruling, but I just want to make it proper that we'd also want redacted. So they're saying they're saying just a few days later, Valentine's Day, Kouri made Eric a sandwich and placed it on the seat of his truck along with a supposed love note. I don't believe that has come in. I respectfully disagree. I don't think it's ever come in. He had trouble breathing. And I just want to make a record on that. But I understand your ruling.
Okay. Let's see. I think that handles 2-76T.
Honey, you make records like you make sandwiches, honey.
Let's go to 2-77T. Defendant objects to redacting the following two sections. Line 20, page 21, lines 14 through 25. This just seems to be a self-serving statement by defendant that is not necessary to provide context for, or explain any of the other unredacted statements. Why is this necessary under Rule 106?
Page 21, lines 14 through
Is
25.
it homemade sandwich, Kouri? I saw on X a lot of people feel like she has a strong case for appeal, like she's being railroaded, like I said.
We don't need that. We'll withdraw that.
Okay, thank you. And then, same exhibit, 2-77T. Please go to page 25. Lines 2 through 16. I'm not sure why this is Rule 106 material either. It is almost entirely Ronald Darden statements with just Ms. Richins making non-substantively responsive comments.
Lord, y'all's confused. Let me shut my office door.
Okay, I don't need anything above line 14, but line 14 is the beginning of her sentence that starts on line 17.
Okay.
So we need 14, 15. I don't really care about 16. It doesn't, I think he's talking over her, but 14 and 15 is the beginning of the sentence that they start with 17.
And what's the problem with lines 17 through 19? This is Kouri Richins' statement.
She's saying her mother was telling her, so it's triple hearsay. It's her mom telling her what her mom read about what other people said.
Okay, and then Doesn't she go on to talk about that on the following pages?
You ain't read that far. Lord have mercy. Y'all been at this for an hour.
I'm not sure what you're asking me.
If we don't include lines 17, 18, and 19, we don't know what she's talking about when she says stuff showing that I bought lunch at Mirror Lake, like I didn't make any fucking sandwiches.
He just be cussing and we just be letting it ride because it sound like in the criminal justice system.
I don't.
It's context for what she's talking about.
I don't
later.
think. Well, I don't think any of it should come in. I mean, it's all talking about a triple hearsay statement, and she's addressing it.
It's her making comments about what did or didn't happen with respect to the sandwich on Valentine's Day.
It's
That's
her
relevant.
responding to what the triple hearsay statement is saying.
Well, that's fine, but her
It's so
these
smooth.
statements
Like, I know he be
made by
cussing people
other
out.
people do not come in for the truth. Her statements are admissible as categorically non-hearsay.
So you're going to make an instruction on this one as well?
I'm making an instruction on all of them
Okay,
that
I'm
they
sorry.
cannot consider
You're not sorry.
the statements that are made by people other than Ms. Richins for the truth of the
All
matter.
right, talk about argumentative. You're
I'm
not sorry because you
I
keep doing the
understand
shit.
that you were suggesting that you're making one instruction for everything. I don't know how they're introducing these. I don't know
I
if they're
can
all.
make an instruction every single
That's
time.
what I'm asking.
Yeah, happy to.
Okay, that's.
Any other objections regarding this?
Your Honor, we don't think any of it should come in. We think it's all hearsay. We object to all of it.
You're going to have to be more specific. Do you
Right.
believe that Ms. Richins' statements are hearsay?
Yes, because she is incorporating into her statements the hearsay statements that others are making about what happened in order to give her own explanation. So, yes.
Okay. Any other objections?
No, sir.
Defendant's objection is overruled. Ms. Richins responding to questions posed to her by other hearsay speakers is categorically not hearsay. The court can instruct around the possibility that the jury might consider the statements of speakers who are not Ms. Richins accepting their statements for the truth of the matter. Mr. Bloodworth, anything further there?
No, Your Honor.
I'm sure she's a terror to live with her
That handles
need to be
277.
right about everything on top of
All right, let's
her
go
being
to
a lawyer.
278T. Mr. Bloodworth, take a look at page 11 with me, please.
So, Your Honor, maybe I can head some of this
Please.
off. So this
Thank you,
along with, I
Bloodworth.
think it's 2-90, right? This all goes to recovery of the walk the dog letter, which is entangled with a whole lot of Kouri Richins' in jail. I have a proposal.
Why is recovery of the walk the dog letter going to be an issue that comes in before the jury? I've already ruled on any motions to suppress it.
I don't think it has to.
I'm so sorry. Which number are we looking at? Right now?
Currently,
Jesus,
we're looking
pay
at
attention.
78T and 90D.
So at the outset, from the state's
That's
perspective,
rude.
introducing the
Not
walk
even
the
giving
dog
it the
letter,
attention you
how
should
it was
be.
recovered, I don't know that matters. And but I can envision a scenario where, for example, defense
Oh,
the defendant has said that this 6-page walk the dog letter, it's been redacted down, but 6-page walk the dog letter was part of a 65-page fictional manuscript, and it was recovered from the middle or whatever of that manuscript, and the context of it the context of the 6 pages is within the volume of a book. That is untrue, and we could prove that by proving how it was recovered.
Let's go in order of events, though. In terms of Jeff O'Driscoll testifying about the walk the dog letter.
Go
ahead.
Here's my proposal.
Please.
I would like to show Jeff O'Driscoll a copy. Is this an accurate depiction of a 6-page letter to Lisa Darden written on either September the 12th or 13th, 2023, that investigators recovered on September the 14th, 2023, from a book that was among Kouri Richins' personal possessions?
Any objection, counsel?
Rather than bringing in, so the idea would be he's not going to bring in 278T and
No, just we'll start there, and it will inform what we do with 78T and 90D.
So the way he just explained that answer, I don't know what I could object to.
Well, if you object to foundation, you're going to create a problem. So I just need to have what he's proposing is that question be non-objectionable based on foundation by stipulation of the parties.
Well, I don't plan to object to that question because I don't want to get into the fact that her cell was rousted.
Right.
So, I mean, I'm certainly not going to open that door.
Okay. So if it comes in that way, as I understand it, there's no need for the state to use 2-78T or 290D in its case in chief. Is that accurate?
Correct.
Okay. Ms. Nestor, anything further there?
No, sir.
Okay.
She pissed. She's pissed.
Okay, then can we go to 2-93T?
You think they had a back and
Think
forth
this
like
is Ms.
it
Richins
was?
talking about speaking with Ms. Bramwell and Heber?
Just very briefly, Your Honor, I think they missed redacting the word jail call on the first page on this one. If we could just make sure they do that.
On page 2?
On page 1, the cover page, up at in the heading.
Oh, I don't think we're showing any of the cover pages of any of these, right?
I think they have the dates on them, so they may.
Yeah,
want to.
Okay.
Your Honor, we did miss that. We will fix that.
My apologies. Okay, very good. So jail call 1 will be redacted from the caption on page 1. Thank you. Help me out. What is the probative value of this one, Mr. Bloodworth? And is this only one that might come in rebuttal, or is this the case in chief?
No, Your Honor, the state withdraws this one. Now that we've resolved the Bramwell issue and she's testified, this is no longer necessary.
Very good. 2-93T is moot.
What?
All right, 2-94T. Part of this is regarding the vacation booking statements. Part of this is Kouri Richins making statements regarding the vacation booking statements. And part of this is regarding the thing in Heber. Candidly, the statements or the back and forth regarding the quote unquote thing in Heber is pretty confusing. The first part, I think, is more clearly probative.
This one also, Your Honor, they missed jail call on the cover page. If we could just redact that.
Scott, page 1 of 2-94T in the caption, please redact jail call 2 from the caption.
If we could get to some testimony, because I think we're going to have a lot to talk about with O'Driscoll, because he got a lot going on, not just with the investigation. Honestly, he got a lot going on outside of the investigation. Do y'all think it's a good idea to have him as the last person? Because I have a fear that the PI, Mr. Gabler, is going to be more
Your Honor,
solid than O'Driscoll.
Because of the way the evidence came in, the state will withdraw this one as well. I can envision some corner cases where we might want to revisit it, but for now, let's just set it aside.
Very good. And then the video 2-110.
Yeah, I should have been last. Y'all thinking the same thing. Because even if he does amazing on the stand, he still got to test for what he threatening. Oh, girl. The PI was petty. Okay, PI was petty. He said, "You want to play games? I'm sitting up here in pain. I ain't had my medicine." He put that brace on, so anytime she came at him crazy, it looked like she was attacking a handicapped person.
Okay. That's right.
It didn't look good.
The state's docket 1165. Anything further on that,
No, sir.
Mr. Bloodworth?
No, sir, nothing on that. We recently identified 3 additional jail calls that we've redacted. We'll send those to the defense.
Oh, y'all done found some more jail calls?
Introducing them today.
I got you in just a second, Kathy. As soon as I finish this.
Similar discussions.
Understood.
About O'Driscoll's mess.
And then, let's see. May I ask about the state's motion to admit redacted exhibits 8-57R through 8-63R? That is the state's designation of prior consistent statements by Carmen Lauber. May we talk mechanics for just a moment?
Yes, sir.
How are these coming in mechanically?
So, Your Honor,
They get ready to go into Carmen. I'm going to pause this for 2 seconds real quick.
O'Driscoll today, I will ask him about conduct of.
Real quick, Miss Kathy, and for anybody else who didn't see it, O'Driscoll was the lead detective after Deputy Woody. I keep wanting to call her Woody. Deputy Woody got her K9 and got the fuck on. Now, O'Driscoll, not only was he the lead detective that ended up going after and he made the deal with Carmen, right? So he was pretty much telling Carmen and telling what was the dealer that don't have no memory? The Robert Crozier. He's telling everybody that should have got charged too that hey, he's not worried about charging them as long as they tell on Kouri. Then he also ended up being in the process Carmen Lauber's saving grace. He got her, she ain't had a drug test in 2 years. I think he's her PO. He's watching her ankle monitor. He's doing everything for her. He's showing up in drug court with her to testify, to keep her on the up, just so that she stays in a good space so that she still does what he needs her to do. On top of that, there was another witness who testified that he actually gave what was it? He actually threatened one of the witnesses, Miss Isbell, because she didn't, she said she was being threatened by either him or Maynard. So not only are they the lead detectives, but they seem to be everybody's everything, and they don't like the way that he has been handling himself outside of the investigation. So as much good as he may have done for the investigation, he also got some stuff that is outside of the investigation that I know they're going to bring up about his conduct, the way he offered these deals, the way he put these deals together, who he gave a deal to, how he gave the deal, how he treat people that don't cooperate against Kouri, and how he requested stuff against Kouri. Oh, Laura, I seen that. I seen the video, and I was wondering who then said something to my niece about her life because she was throwing all the shade, and I was wondering what happened. All right, back to it.
Carmen Lauber. Ask him about the defense's question. He was present when the defense questioned Carmen Lauber about certain statements. In context, are those statements?
Oh, excuse me. Sorry.
Fair. And then move to admit the various 57 through 60, whatever.
So I appreciate that the state has evidence through Jeff O'Driscoll and perhaps others that the arc of the interview, particularly the conduct by law enforcement officers or investigators and Ms. Lauber's responses thereto, are not the same as suggested by defense's cross.
Keisha, that's
of
scary.
Lauber. Right. But you can elicit that evidence
I
through
don't-
Mr. O'Driscoll's, Detective O'Driscoll's testimony. And to the extent you need to show that Carmen Lauber testified consistently with versus the suggestions of what she said or what she said on cross, you can certainly do that. My question is, though, it seems like a lot of this is being shown the arc of the investigator's conduct rather than just Carmen Lauber's prior consistent statements. Now, I understand context matters, but do we really need all of it, is my question.
Your Honor, the state tried to narrowly tailor the amount of information. I think,
And to be
I'll-
clear, I recognize that we went from 900 pages down to 100-ish.
correct.
So I understand that.
I think those 100 or so pages, narrowly tailored, are kind of the minimal amount to show the motive, Carmen Lauber's motive, that it was more, certainly there was a self-serving piece, but there was a lot more than a self-serving piece. And that she was not motivated by Detectives O'Driscoll and Maynard bullying her. I think the full expanded 900 pages show that the best. I think the 100 or so we called.
No, LaPanda, we have not seen the jury yet, and we about an hour and a half in almost. They're still arguing about what should come in or not come in, what should be redacted or not redacted when it comes to Detective O'Driscoll.
Your Honor, we don't intend to publish them.
You ain't missed
We
nothing.
intend to make a few points from them through.
Hell, they could have did this on their own and brought us in with the jury. Shit.
Provide them to the jury, and in argument, argue something like, you heard the defense cross-examine Carmen Lauber. You heard Detective O'Driscoll's testimony regarding those interviews. You have them before you if you want to, or you have these excerpts before you if you want to dig through them and determine for yourself what the evidence proves.
Okay. I appreciate the efficiency of this. I have a genuine question as to whether I can send
Hi,
these
little one.
transcripts back into the jury room when I'm not sending other transcripts of other testimony back into the jury room. I have some concern
Your Honor,
that
it's
would-
not testimony. It's
Well,
evidence. It's an interview.
I mean, we'd have to go through the Crawford analysis to figure out if Ms. Lauber's statements were testimonial. Now, there's not a Crawford problem because she was on the stand,
Correct.
but whether these qualify as testimony with respect to the concern that providing transcripts of certain testimony would give that certain testimony undue weight when transcripts of other testimony are not provided, that I have a genuine question about. So I'm not suggesting that you can't publish.
Sure.
I'm asking whether you have to publish but not admit. But she was in custody. She was being questioned by law enforcement officers. I think there's at least a reasonable question as to whether this would qualify as testimonial, and quote unquote.
I think two things, Your Honor. in some measure, that's why the state moved to admit the entire shebang. But I appreciate the need for efficiency.
Right.
The second thought I have is, to the extent that the defense wants to further cross-examine Carmen Labra on these, or Detective O'Driscoll or Detective Maynard, they're here. We can all recall them easily.
I agree. Yeah, no, I agree with all of that. It really comes back to the issue of whether these transcripts go into the jury room. Publishing, you're right. You have the right to publish them to the extent you want to. I am not persuaded sitting here right now that they go into the jury room. So we don't have to necessarily reach agreement on that piece right now, but how do you want to proceed with Detective O'Driscoll on recognizing that they may not go into the jury room?
Your Honor, that would alter the state's direct of Detective O'Driscoll, because we would end up publishing 100 pages of transcripts.
You have him as video or audio though too, right?
Well, right now, we only have the transcript. We were waiting, video editing is long and expensive.
I see.
And so we were waiting to nail down the transcript to then conform the video.
Is audio easier? Do you have audio files?
What did
Ms. Shermack is saying no.
it's just it's the video file is the audio file.
I see. Okay.
It's one.
I see.
So there's no distinction in terms of editing time between a video and an audio file.
All right, pause there for a moment. Maybe I may be taking on more than I need to. Ms. Lewis, what's the defendant's view of this?
Your Honor, I mean, we object to these coming in this way. I think that
When you say this way, what do you mean?
by publishing any of these transcripts, I think you're correct that the appropriate way to do this would be through direct examination of Detective O'Driscoll. They can certainly ask him questions to try and rehabilitate what Carmen Lauber said.
Can ask him questions about what he said. They can't ask him questions about what she said. That'd be hearsay.
I understand, but the problem that as they see it, if I understand it, is they're trying to put forth that she wasn't influenced by law enforcement. So they can ask questions of Detective O'Driscoll about that. But putting these in, I do believe is a Crawford problem.
Well, hold on. I need you to compartmentalize the objections here. These are being offered as prior consistent statements of Carmen Lauber to rebut a charge of either recent fabrication or undue influence.
I understand.
So any objection under that rule?
Yes, that should have come in under Carmen. During cross-examination, it's fully within our right to pick out portions of this interview.
But you can recall her, right?
I don't think that's our job to recall the state's star witness. They had her on the stand.
I just asked you a yes or no question. Would you start there for me?
Could we recall her? Yes, that is something that could be possibly done. I don't imagine what world a defense would do that. But
And correct me if I'm wrong, you had the transcripts when you cross-examined her, right?
yes, but so did they. And the appropriate way to do it would have been to try and rehabilitate her on redirect, which would have then given me a chance to go into other statements.
They sought to,
During cross.
and I limited their ability to put in the whole 900 pages.
That's not how you rehabilitate. You rehabilitate by asking questions. It's not by putting.
Y'all both be talking to this judge like he ain't the judge and he can't put y'all in the claim.
For example, by admitting prior consistent statements. And so I just need you to stay focused on that rule for a moment. I know I'm interrupting you.
Yeah, you are.
I don't understand how you think they were supposed to admit prior consistent statements.
Through testimony.
That's not a prior consistent statement. The whole reason we have the prior consistent statement rule is because the testimony goes in a different direction, or there's a charge of recent fabrication or undue influence. Then you have the prior statement come in as substantive evidence.
Only while she's on the stand. They didn't even attempt to question her about whether or not to pull out these portions to show, oh, look at, you weren't unduly influenced. Look at, you said this, you said this. Is that correct? Is that correct? That's how you would normally see this done. Then I could have cross-examined her. And I also want to point out that they have taken very small portions of this that leave out the portions of the interview where she is being influenced by statements of law enforcement. This makes it look like, I mean, they've cherry-picked what they want. And for example, I want to pull out the May 10th interview. I don't even understand why this would be coming in. All they've pulled out is a conversation between Ms. Whistler and Ms. Lauber. Ms. Lauber is supposed to testify before the grand jury. That's going to open up a whole door of speculation and what happened. I don't see how that has anything to do with what we're even talking about. And as I go through the transcripts, it's very much just what the state wants the jury to hear. I mean, if we're going to do this, which I think is completely inappropriate, this is a Crawford problem. This should have been brought in through testimony when Carmen Lauber was.
We should have had a Crawford counter. How many times have they claimed Crawford violation?
Bring in what they want through Detective O'Driscoll, because we still have an opportunity to cross-examine him. But to just send back portions of a transcript that we've not been allowed to cross-examine on, that point out to the jury just what they want the jury to hear, is inappropriate.
And I apologize, you're jumping around a little bit. So put aside sending transcripts back. I have concerns about that. Do you have any law for the proposition that prior consistent statements can only come in through the witness that makes the statement?
Well, I would point to a case. Let me pull it up again. I had it. Just give me a moment.
You know what? I was getting ready to go heat up the rest of my coffee because I'm like, clearly my brain is not.
One moment, please.
It's not following because she lost me twice. And now I don't feel bad because the judge is saying you're jumping around. This is not like, good God almighty, you trying to confuse me? My damn eyes is crossed.
It's 366.
Jesus.
867, State of Utah, in the interest of JC.
I'm sorry, would you give me the site one more time?
366 P3rd 867. And I direct the court to footnote 8.
Okay.
Sorry.
All right, so I understand your objection there. Tell me why you think it's a Crawford problem. You had the opportunity to cross-examine Ms. Lauber. You did cross-examine Ms. Lauber. You used part of these interviews to cross-examine her, to challenge her on whether she just asked the law enforcement officers, investigators, just write her statement for her. I don't understand what a lack of confrontation Ms. Richins has had here.
Because what is happening here is now they are basically crafting testimony on her behalf. They should have asked her these questions. I haven't had an opportunity to cross-examine her on what they now want to bring in. They should have brought it in through direct, and instead, which I get was difficult with her. You know, she said she didn't remember anything. Instead of doing the hard work to try and ask her questions, they just want to put it all in, and they want to cherry pick what they wanted her to say, which clearly would have been very difficult to get her to say. So the easy way is here. We're just going to hand you the transcripts that show you what we wanted Carmen Lauber to tell you, but instead, here, just read it without putting in the whole story or giving me a chance to go back and cross-examine her. And I think requesting us to recall her is burden shifting. That is not what our job is. That's not what we needed to do. They needed to take care of their witness when their witness was on the stand.
And remind me, you objected to the addition of any part of the transcript at the time they offered it,
for the
correct?
same reason. They offered it after she was off the stand.
Had they offered it the 900 pages when she was on the stand, you would have said, okay.
No, I would have said you need to cross-examine her, redirect her and rehabilitate her testimony.
And so how do you see the rule regarding prior consistent statements?
Because, baby,
they need to get it through her. They could have put on prior consistent statements.
You just said,
I don't understand. You're saying the prior consistent
what the
statements
fuck?
never come in. You only can ask questions. Please help me understand.
both of us, because, man, what are you saying?
I don't understand. I'm sorry, Your Honor.
Oh.
I really am not following what you're trying to say. I have never.
And we
seen
ain't following
any
you.
other victim through a witness. That's why we have witnesses. If not, why have any witnesses? Let's just hand the jury all the evidence. Let's hand them all the transcripts of.
Well, no, be fair to how the rule works. Somebody testifies on cross-examination. Defendant makes a charge of
I
recent
didn't say it, you
fabrication.
did, because one of my
And then the proffering party has an opportunity to offer prior consistent statements to rebut the charge of recent fabrication. I hear you saying, no, they cannot offer the prior statements. They can only ask more questions.
They can offer them through the witness. They can say, is this your statement? And what if she says, I don't remember that? Okay, then they can refresh. What if she says, I don't remember that? Well, then it doesn't come in.
Okay, I think that's where maybe you and I differ on the way the rule works. Do you have any citation for law that says, unless the witness remembers these?
it doesn't come in because anybody would say they don't remember, so we're going to offer up the transcript.
613 of the Utah Rules of Evidence that talks about.
Now let's be real. We understand these people have.
Well, this talks about prior inconsistent statements, but after one's given an opportunity to explain or deny the statement, and
Because
after
I've
one's
never
given an
seen where
opportunity to
somebody
examine
said
the
it
witness
don't get to
cross.
come in at
We don't know
all.
what she would have said. We don't know if she would have said, I mean, she may have very well said, no, I didn't feel influenced at all. You know, that's fine. They could have asked her that question. Then I could have cross-examined her or recrossed her to say, well, what about this? What about this? What about this? Now I'm denied any opportunity to do that by just putting in statements. And I mean, I really don't know what else to say. I do think as I look through the transcripts, they have only picked things that they want in that we don't know that Carmen Lauber would have agreed to. But had they wanted to put them in through her, at least then I could have questioned her I could have questioned her. I could have said, you know, so this didn't make you feel pressured. So that didn't make you feel pressured. So they said this, so that made it, you know, so you felt you were telling, I don't know. I mean, you see where I'm getting. And I don't have any opportunity to do that in this way. I can ask Detective O'Driscoll questions. We can cross-examine Detective O'Driscoll, and the jury can make a determination of that. But by cherry-picking statements that they wanted Carmen Lauber to testify to, but didn't ask her, I think that's error.
It's not the cherry picking; it's the root, right?
It is.
I mean, you cherry picked statements too. Everybody cherry picks
right,
statements.
and they could have done it on redirect, and they chose not to.
So again, it's the root, not the cherry picking, right? If she were on the stand, the cherry picking would not be a problem.
They could have, because then I could have gone back and pulled out other statements.
I think we're agreeing. Okay. All right. All right. I take your argument seriously. Mr. Bloodworth, I'm going to have to take a look at this real quick. I understand this to be a threshold issue with respect to Detective O'Driscoll. Is that right?
Yes, Your Honor.
Okay. Anything further at this moment?
Your Honor, I'm pausing. Can we have 5 minutes?
Of course. Just so I'm clear, we'll take 5 minutes for you to confer with your team, and then you'll tell me whether this is a threshold issue that I need to decide before Detective O'Driscoll takes his
Correct, Your Honor. It is now. That may change.
Okay, understood. We'll take a 5-minute recess. Thank you.
And still no jury. All right, guys, 5-minute recess. For him to make her, I think he's doing this to make her feel heard. I think this may be an I am nobody's legal anything, but I think this may be lost in interpretation. Her understanding of this particular law and how he interprets his law, which is the way this works, right? It seems to be where they're having the clash. I think there needs to be like a quick, I don't want to call it remedial, but maybe a way to get on the same page, or he give his interpretation of the law and she can go either find some case law that says otherwise or hush, because they are leaning on Crawford like it is Jesus' biggest sandals. I have never in my life heard Crawford so much. So there is a way that they have interpreted it that they stand on, and there's a way that he's interpreting it that it's just not landing. I don't even know if it's hovering. I don't even think his interpretation is in the same airspace as her brain. It is just not. Oh my God. In so many words, Hannah, she's basically saying, and it's crazy because we're actually dealing with people who have scrambled their own eggs, right? We're dealing with people who have done things in their life that may have affected their memory long term. So she's basically saying in so many words that if you make a statement at some point, Hannah, and I come back later and ask you about that statement, and you're like, I don't remember saying that. And then I show you where you said it, and you're like, okay, well, that's me, that's my voice, but I still don't remember, that conversation. Then I can never use that statement as if it was never made. And, for some people, you literally for some people that might be like, oh, you don't remember, so it didn't happen. But if I have an actual police interview of you making these statements with your rights read to you and all, just because you don't remember making that statement doesn't mean it wasn't made. And she's saying if Carmen, who has admittedly said, her and Robert Crozier, that their eggs are low-key scrambled. And we know because Carmen started making calls. Help me out here. I know we did it. I don't remember the exact date and time, but if I don't remember these dates and time, I'm going away. Help me out here. Tell me when we did it. How many deals did we do? What time did we do it? Like, she was trying to refresh her memory because she genuinely didn't have one, but she made the statement to law enforcement. So basically they're saying that the state was supposed to ask Carmen if she remembered making a statement. She says, no, I don't remember. They show her the statement that she made, or the transcript of that she made, of the statement she made. And if she still says, I don't remember making it, then they can't bring it in at all. Why? I literally have a video where at the beginning of this interrogation, she says, yes, I am Carmen Lauber. This is how old I am. This is where I live. And this is X, Y, and Z. And she's making the statement to law enforcement. Why would I not be able to use that? Wouldn't everybody be able to? That's why I said this must be an interpretation thing, because I've never heard someone lean on that. I'm like leaning on it, like it's the leaning on it, like oh God, leaning on it like it's the Bible. If that's the case, when would the state ever have a case? Because the state don't get to choose their witnesses. They left with whoever this happened to and who was around when it happened. You think the state would have chose Robert No Memory ass Crozier? You think the state would have chose Carmen Lauber? Hell no. But if you have somebody that doesn't remember, doesn't recollect, was in a state of being elevated or having something in their system, what the heck would they remember? Hell, let's not even say it was illicit. If it was somebody on anesthesia and they talked to them when they was at the doctor's office and they said, you know what, I remember, but that was traumatic. I was in a car accident. I don't remember that. But I know I talked to somebody, but it was so many things going on at once. I don't remember that. That doesn't mean it didn't happen. Doesn't mean I didn't say it. Doesn't mean it isn't true. It just means that my brain was fricasseed. Exactly, and that will be another tactic. Get up there and say you don't remember it twice, and they got to let you go. He has the patience of Job. And he has not said one cross thing. He has not. And I think that's who said that he doesn't raise his voice and his voice doesn't get any deeper. So it still comes off the same. It comes off even killed. After the dentist, man, people be saying some craziness after the dentist. Or, yeah, after any surgery, really. I remember a while ago, Tiff Ann sent me a TikTok of a guy who was telling on himself after he had surgery and had messed around and told his wife about his daughter that he had with another woman that she didn't know about. That he didn't want her there. Call his woman. He want his daughter. Gotta wake up every morning and watch a video. I like trippy Thursdays. Let me go and close my office door again. They're back. Ooh, wee. This is teetering there. It's teetering there, Laura. This is definitely some of the patients we saw reserved for like Daryl Brooks. Daryl Brooks definitely got a level of patience I've never seen in my life. Yeah, Hannah, something like that happened, and you guarantee going back to sleep. What's to say? She was so frustrated. That lady, I'm sure that lady had a adult beverage membership during that trial. I'm sure she went home every day. Like, nobody talk to me, please. Because I can't imagine. I remember years ago when I used to take phone calls, I used to, like, I didn't want anybody to talk to me ever. Like, when I got off work, the last thing I wanted to do was talk. That's a good question. Do y'all think the defense is stalling because they know this is the last witness and they're not ready for their case? Man, I wonder. It's also making me feel like, I'm gonna tell you the truth. It's also making me feel like we don't that maybe the way that they said that O'Driscoll was handling himself, we may have heard all of it. Like for me, when I see stuff like those threatening text messages and hear how involved he is with every single person, it's almost, it could be looked at where there's smoke, there's fire. So he must have done more and they're just holding it for when he hits the stand for cross-examination. But now that you're going so hard on the things that he could bring in, it's almost starting to feel like, is that all he did? Not saying it's right to threaten nobody now, but I'm just saying, is that what y'all getting ready to bring up on cross? The same things we've already seen. Paige. Now, when it comes to Paige Reese Whitaker, after her elected DA, after Fonnie said, if y'all want better results, elect better judges, and now that lady is up for re-election, I have been, until now, silently waiting to see how that goes. Because if she's re-elected, Fonnie, the people have spoken. I believe she does have an opponent. So. Hold on, guys.
To see.
You said what, Tiffany?
Lock her up. We have seen everything that we needed to see. Get her out of there.
Well, actually, there's a lot of people who believe that this is getting ready to be like Casey Anthony, that she's being railroaded and that they're just being mean.
And I think all the people that think that need to be investigated right along with her. Because what you up to? Hiding secret. What you up to? What you trying to hide from everybody? You done wrote a book too? What you know? What bad real estate business you practice? I say investigate them all. I was calling to tell you that I was just informed by Mr.
Hold on.
James.
My mic is open.
It ain't nothing bad.
Oh, okay. Well, we know you, honey.
No, I was informed that the Chargers have now listed Tira as third string defensive end. I believe that's no longer on the practice squad, so now he's on.
Go Tira!
I said, James, I don't know what that means. Those sports.
Yeah, that means that he's on the squad. They said, hey, Tiffany.
Hey, y'all, morning. And speaking of, let me show you these dumbass hot dog buns that Kroger came up with. Not Kroger, Pepperidge Farm. I can't even get a good one because it pissed me off so bad. Look at this. Look at this. What in the asymmetrical bob did you do to my damn bun?
Oh, yeah.
Why it's like that? Talk about split top. That split down the middle. Don't cut it at an angle. What the hell? Girl, piss me smooth off.
It messed up your hot dog.
Messed up my bratwurst. Stressing me out, y'all. I can't. I'm so good. Why you been sleep? Because that's the only way I can do is sleep my crab shot.
Lord.
I ain't laughing at you, Destiny, because I know you're saying. Are. I'm not, because I've been there. I've been there. I'm laughing at you saying that you got sleep is the only way you can get to it. You didn't pop you some muscle relaxers, honey.
Jesus.
Took some medicine. Put that heating pad on
They,
my back.
the Patriots booted. Stephon did. Oh yeah, I saw that. No, that was what Tiffany was saying. Is my cousin? Remember, I told you my cousin was drafted to the LA Chargers, and then he made it through and had a couple great moments, but he was still kind of like on the practice squad, not on the actual like main. What is it, like 100 person list, the main roster, and he has been booted up to third string. So he's off the practice list and on the actual roster for the Chargers. His name is Tira Edward. Yes.
James texted me back talking about he got a promotion. I said, okay.
He got a promotion. He got to talk to you in terms you understand.
Yeah. Girl, don't worry. I don't understand shit. Listen, I told him, I said, go sports.
Go sports. Yeah. Jesus.
That's what I don't got to understand. But
Jackie said she's going to a basketball game today. I was like, oh, okay.
Oh, who's playing?
I know she loved the Sixers. I just don't know if they got a game today. But she said this after.
Oh, girl,
I think it's something else. I think it's the Yeah, I think it's something else.
Please. Girl, you shut it. I'm trying to help you exercise your stomach muscles. No, I want to exercise.
I go to South Carolina next month for my nephew's draft party. Oh, that's gonna be fun.
Mr. Bloodworth, before
we back.
I need to fix a misstatement that I made while discussing Detective O'Driscoll's potential testimony. I made a comment in passing that he cannot relate Ms. Lauber's statements because it would be hearsay. That is overly broad to the extent that the statement by Ms. Lauber that Jeff O'Driscoll would seek to relate while testifying qualifies as a prior inconsistent statement under 801D1A or a prior consistent statement under 801D1B. It is categorically not hearsay and he can relate it. By the same token, it can come in through him. Ms. Lewis, I took a hard look at the case you cited me to, 366 P. 3rd 867, footnote 8. There, the Utah Supreme Court related the competing positions by the state and the respondent. Those competing positions are substantively identical to the competing positions of the state and defendant here regarding how statements under 801D1 are to come in. And the Utah Supreme Court expressly declined to reach the issue. They did not rule that they must come in through the declarant. So, as I sit here today, there is no authority for the proposition that prior inconsistent or prior consistent statements can only come in through the declarant witness as long as the declarant witness testified and was subject to cross-examination. Indeed, it is defendant's cross-examination of Ms. Lauber that creates the foundation for admission of prior inconsistent statements based upon Ms. Lauber having not remembered or having forgotten, though that's not what the state is seeking to do here, and prior consistent statements based upon an express or implied charge that Ms. Lauber was acting from a recent improper influence or motive, to wit, pressure applied by, among others, Detective O'Driscoll, the U.S. Attorney's Office, agencies like that. There is not a Crawford problem here. I also have another thought regarding the transcripts going back, if you want to discuss that.
So maybe we can get the court's thought and then I can incorporate that into the state's position.
Sure. Under Wyatt v. State, 2021 UT 32, under paragraph 21, the Utah Supreme Court abrogated the common law rule that prevented testimonial transcripts from going back into the jury room based upon a concern of undue influence, on the basis that Rule 17K of their Utah Rules of Criminal Procedure does not allow for any categorical exceptions to exhibits going back with the jury, because the jury may take with them, quote, all exhibits, end quote, except those, quote, that should not, in the opinion of the court, be in the possession of the jury, end quote. Now, typically that's guns, knives, poison, explosives. I still have some concern that given the volume of testimony that the jury hears, the only transcripts they would have in the jury room being this 100-ish pages of Carmen Lauber would attract some unwanted attention on appellate review. But under Wyatt v. State, 2021 UT 32, there's no categorical exclusion of them. Take it from there, Mr. Bloodworth.
So, Your Honor, it's the state's position. I know I'm recapping a little bit of what you just said. It's the state's position that the court can admit the transcripts through Detective O'Driscoll. We don't need the declarant, Carmen Lauber. It's the state's position that there is no Crawford issue, in part because of the 801D1 requirement for opportunity to cross has been satisfied in this instance. It's the state's position that the defense, to the extent they want to recall Carmen Lauber, is not burden shifting. It's just a defense strategic choice. And it's the state's position that the transcripts can go back to the jury. Now, having said all of that, prophylactically and out of an abundance of caution, the state is trying to, through her attorney, recall Carmen Lauber, put the transcripts in through her, and then publish 100 pages of transcript. As much as the state thinks that is horribly, horribly inefficient and unnecessary. We've reached out to her attorney. I do not yet have an answer.
Okay.
This is a threshold issue for, I don't know, the midpoint of Jeff O'Driscoll's examination. So I propose our next witness is Chris Cochagimos to clean up some stuff from yesterday. I propose we next call him. We then begin the state's direct examination of Detective O'Driscoll. That'll probably take us till lunch. I may have a better answer at lunch as to how the state will proceed.
Okay. Let me just ask some mechanics questions. Why can't the state just ask Jeff O'Driscoll a bunch of questions about whether certain exchanges with Ms. Lauber occurred? And to the extent he doesn't remember or can't remember specifically, use the transcripts to refresh his recollection and even show the jury, publish them at that time, but use him as the root. And if you want to call Ms. Lauber, you're entitled to do so.
Your Honor, that may be the route. anyway, and it may just, from an efficiency standpoint, going through the questioning to ultimately get to refreshing and publishing, it seems to me that that's what's coming. It will be more efficient to just publish the 100 pages.
Okay.
Because that's where we're going to land anyway.
All right. Ms. Lewis, please proceed.
I just want to make a record.
Go ahead.
We stand by our objection that allowing prior consistent statements to come in without a sponsoring witness is a violation of both the Sixth Amendment right, of our client's Sixth Amendment right, and Crawford versus Washington. It also violates her right to due process. Under the Utah State Constitution and the federal Constitution, she is not receiving a fair trial. And the remedy that we should recall the state star witness absolutely is burden shifting, and we stand by our objection. If those 100 pages are going to be published, we want all of it published. We want all 1,000 pages.
All right. And how do you want that to occur? Do you want to just play the interviews with Ms. Lauber?
Sure, we could do that. We could just play them all. They're 7.5 hours, but that's how we want to do it.
And tell me why you want to do that.
Because there are numerous other portions of the interviews where she is being influenced by law enforcement and shows that she's willing to just go along with whatever they say, just as she stated. But I think to pick out, particularly, like I said, the May 10th interview, there are a lot of things she says in that interview that are inconsistent with all of her other statements, but the state just wants to publish that she was going to testify before the grand jury, which I don't even understand that. I mean, all that does is cause the jury to speculate and confuse issues. And that's just one example out of what they've pulled out of the transcripts.
We're back where we started, Mr. Bloodworth. This is the position the state originally took. Does this change anything?
Your Honor, it's largely the state's initial position. The initial position of the state was then not to publish them, right? It was just to send them back so that the jury could, if they wanted to. I'm happy to send the whole things back.
Ms. Lewis, speak to that.
We're not asking, that's only if, we are not suggesting that that should happen, only if we're overruled. We'd rather it all go back.
Part, you gotta be a little bit specific.
We're not suggesting, it's not our position that any of this should go back. We're only saying if the court's going to allow some of it to go back, then under Rule 106, we need it all to go back.
Forgive me, you've pivoted again. It's stay away from going back. Let's just stay on publishing. So I understand defendant's position to be if any of it's published, all of it has to be published.
Correct.
Okay. In response to that, the state, as I understand, is suggesting I'm inferring in the interest of efficiency, rather than publishing all of it, just make all of it available to the jury through the recordings, and then allow counsel to make whatever arguments they want to make about, you should go back and listen to this part because you'll see this is what was happening. Speak to that for a minute. You could do that by stipulation.
I'm not going to stipulate to that. No.
So
Our
you're
objection
saying publish.
stands.
Who are you talking to and not that
Imagine
kid?
that your objection to publishing anything is overruled, and that's the world you're living in. How do you want to proceed from there?
I mean, I think I said that, then it should all go back. Or,
Again, you keep skipping to going back. I want you to talk about publishing for a minute.
see, my hesitation is just efficiency. Like I said, it's over 7 hours worth of video. But if that's how the court wants to do it, then yes.
No. That's what I'm asking you. So imagine, here, I'll just make a ruling. I have considered carefully the authorities cited by defendant and the state. I've looked at the text of Rule 801. Ruling is a matter of law that, one, there's no Crawford problem here because Ms. Lauber testified in open court under oath was cross-examined in open court under oath. It is the cross-examination of her regarding the conduct and circumstances in her prior interviews with law enforcement and other agencies that creates the circumstances providing the foundation for admission of her prior consistent statements under 801D1B. So the defendants further, the court is not persuaded that the only witness through whom a prior consistent statement may be admitted is the declarant witness that made the statement. The court has not seen any authority for that proposition. So to the extent the defendant objects to any of Ms. Lauber's prior consistent statements coming in any way, that objection is overruled. So Ms. Lewis, take it from there. Some of her prior consistent statements as designated by the state are admissible under Rule 801D1B. It's how we're going to provide that information to the jury that I need some input on.
Well, I
We
guess-
could just publish. We could admit and send back into the jury room. Speak to those two options.
Well, my understanding was that under the case you just cited, Wyatt, that you were going to allow the portions to go back to the jury room. Did I misunderstand that?
Well, I think there's a basis to do so. It gives me the willies, quite frankly, and that's why Mr. Bloodworth had
Keep
an abundance of
your
caution
ass
saying
out of the
prevent
deliberations.
any appellate
We are
issue
not there yet.
We would just publish. But if the defendant believes, Judge, if you do this, the least prejudicial way for us to do it is to send the recordings, all 7.5 hours, into the jury room and allow counsel to make arguments about what they show and what the jury should take from them. You could do that by stipulation.
No, I don't want to do that. I think that even though it's
You
not
said
efficient,
send them
the
all back there.
appropriate way is if any of the interviews are going to be published, they all need to be published.
Okay, only published.
Correct.
All right. I appreciate your position. Mr. Bloodworth, take it from there.
Your Honor, the state moves to just publish the narrowly tailored versions that we proposed as whatever it is, 8-57 through 63R. I think beyond so, I don't think there's a 106 concern beyond that.
I don't know. We're going to find out, but okay.
Yeah, and as a compromise, the state is fine with sending full videos back or some mix of publish the narrow pages and send a full video back. But the notion of publishing nearly 10 hours of interview is, I don't think it's productive. I think it's a waste of the jury's time.
Okay. Ms. Liz.
We object to it all going back. It's the same problem. The problem arises is the same as, well, let me rephrase that. The jury's been told they're to rely on their memory of witnesses. If the whole thing goes back, they can go over and over and over her statements on the video, which is not what they can do with any other witness. So if it comes in, it needs to be published, and then they have to rely on their memory just like they would with any other testimony.
I appreciate that position. Why are we publishing all of it rather than just the parts or some parts of what the state has designated?
Because there are, I mean, I already made my issue or raised the issue about the May 10th.
We'll get
Transfer.
there specifically. Any others?
Yes. I would have to go through, I have gone through, but to go through right now, every specific part, but there's a lot that's being left out, and a lot what's being left out are the statements where officers are telling her about what she needs to do in order to not have to go to jail, what kind of deals they're willing to make for her, what she needs to do and say, and that's not included. And yes, some of it she was cross-examined on, but there's a lot more statements like that that she was never cross-examined on.
Well, that's choices defendant made, though. So here, in order for me to include additional material, there has to be some basis. Is it a Rule 106 request?
Yes, but in all fairness, the choice was made because that was all that she was questioned on in direct examination. Had there been a redirect back to where I started, then I would have chosen other portions, but I have lost the opportunity to do that.
You haven't, but that's okay. You can certainly have access to this witness.
Well, I think we've made our record on that.
So you don't want to call it. So shut
Are
up.
there Rule 106 portions you want to add, having reviewed the designations?
I think we need all of it. I think the jury needs to see exactly what her demeanor is, how she acts with the officers, how the officers treat her. There are numerous other parts of this transcript that may come in through Detective O'Driscoll. I don't know yet. I mean, I don't know the answer to that fully yet, but there are a lot of other statements by both Detectives O'Driscoll and Detective Maynard that go to show that she was unduly influenced. There's a lot of it.
I know, but you're not giving me which ones they are.
It's because, I mean, all of them.
Okay. All right.
We ain't got a
that-
timestamp or nothing.
It's hard to rule on because it can't be all. Well,
Why not?
if
What do you mean? Why not? And you
certainly
whisper
your
in a dog
position
roar.
isn't
We
that
hear you.
every single statement made by the law enforcement officers and every single answer is evidence of undue influence.
It shows an arc.
That's the state's point.
Right. I know. And now if we're going to do part of it, then we need to show the whole arc.
That's not how Rule 106 works. I need you to be more specific.
I don't have specific outlines right now in the 1,000 pages of transcripts.
But you knew we were going to have to
what
come
we want
to
and what
this
we would-
with Detective O'Driscoll.
we want
We've been
all of it.
talking about it
If
for
you want me
weeks.
to go
We talked about
through
it yesterday, and you didn't come with one
1,000
single
pages
fucking
again and try and
timestamp.
figure that out. I mean, guess we can find some time to do that. But
Okay. So, Mr. Bloodworth, as for today, how does the state propose to proceed?
So I propose we call Chris Cotodemos. I then will call Jeff O'Driscoll. We will get to maybe, 45 minutes into his argument before this will become an issue.
Okay.
My sense on timing, Your Honor, is this doesn't become an issue till a lunch break.
I'm not sure what's going to change between now and then, though, in terms of the issue of whether to play everything or just the parts that the state has designated under Rule 801D1B.
Fair.
So, all right. The issue before the court is the state's motion to admit redacted exhibits 8-57R through 8-63R. The state is offering what it views as narrowly tailored portions of the transcripts of Ms. Lauber's prior interviews with law enforcement investigators and other government agencies as evidence of prior consistent statements by Ms. Lauber under 801D1B to rebut an express or implied charge that when she testified in open court in this case, she acted from a recent improper influence or motive in so testifying. In response, defendant does not provide a sufficiently specific argument that the state has over
Sufficiently specific.
any of these portions beyond what would be permissible under 801D1B. And though defendant makes a Rule 106 argument regarding additional portions that would be necessary to provide context for, explain, or qualify Ms. Lauber's statements, their position is that all of it does. And that does not provide the court with a sufficient basis to rule one way or another whether other additional portions of these prior interviews are required to be included under Rule 106. Based on the record currently before the court and the procedural posture that brings us to this point, the state's motion to admit redact exhibits 8-57R through 8-63R is granted to the following extent. The state may publish these exhibits and use them with witnesses that are on the stand. Sitting here today, the court is not prepared to rule and does not rule that 8-57R through 8-63R may go into the jury room as admitted exhibits under Rule 17K because, sitting here at the moment, the court determines that they should not, in the opinion of the court, be in the possession of the jury to make absolutely sure that the jury does not give undue influence to these specific portions of a single witness's testimony as compared to the testimony of all the other witnesses in this case. Mr. Bloodworth, anything further on that?
No, Your Honor.
Ms. Lewis?
Yes, Your Honor. If we actually would move for a continuance because we need to go through all the 1,000 pages again and figure out what portions should be let in.
Again,
Or it's
you
not
didn't figure it out the
let all
first
of it in.
time?
Then, we don't have anyone in the cry room doing this for us. So we need time to do that. So we'd ask for a 2-day continuance.
2 days.
Yes.
Your request for a 2-day continuance is denied. I don't have a basis to use that much time.
I was about to say.
When this motion was filed 2 days ago, and I raised it with you yesterday morning. Your request for a 2-day continuance is denied.
All right. A 1-day continuance then.
To tomorrow morning.
Yes.
And what is it you're going to do between now and then?
I guess we're going to go through the whole transcript and find out what we want included under Rule 106.
And you're going to file something so I can read it?
Yeah.
So he can rule on it by the morning because you're wasting the jury's time. You said you want to go through it again?
Your Honor, the state objects. Not only
We'll get
was
through 1,000
did the state
pages
file
by
the
tomorrow?
motion 2 days ago with the specific portions, this whole issue was teed up last week when Carmen Lauber testified. I don't think there were any surprises in the motion, and I think the state's motion and the redacted versions it filed were probably what everybody expected.
All right. And Ms. Lewis, you'd be filing something in writing that had additional either Rule 106 inclusions or some identification of where the state has over-designated things, correct?
Yes.
And your position would be that additional parts of the transcript should be shown to the jury, is that right?
Yes.
That is so slow. There's just no way this is going to work. There's no way we can edit the video.
I'm not tracking, Your Honor.
Yeah, each of these transcripts corresponds to a video of an interview, correct?
Correct.
It it would seem that watching and listening to the video is more efficient than reading the transcript.
Oh, 100%, Your Honor. Based on the ruling right now, like 2 minutes ago, we have launched our video editor to create the video now of the narrowly tailored portions. That's how we would publish them. Is by playing the video.
Okay. All right.
One suggestion could be if the state wants to hold off on publishing all of this and see where they get with their testimony of Detective O'Driscoll, and maybe through appropriate direct examination, they can get in the portions they feel are important, and then maybe none of this would be necessary if that decision could be held off. And then if at the end of the day they still want to publish the whole thing, then we would ask that we not hold court tomorrow so we can do that. I think that would be more efficient.
Maybe.
Your Honor, we're going to want to publish it.
Okay.
Let's just cut to that chase.
All right. Folks, give me 5 minutes. Actually, just give me till 11. Okay. We're in recess.
What in the world? This is, there you go. Crazy. BS. What else I got? Wild. What is Ramos doing that he could not have done this the whole 2.5 hours y'all was talking? Because he ain't said a word. And so whatever, each one of y'all gonna go through 333 pages apiece? Like, by tonight, and then who gonna file it? Do what? I am steady talking and was muted the entire time. Absolutely crazy. Everything y'all said. This is wild. This is crazy. This is BS. And what is Ramos doing? To say that we need to go through the 1,000 pages again would imply that you already went through it. So if you already went through it, oh, excuse me, I got the hiccups. What do we need to do again? And to think that you can come into any setting, and I don't care if it's an 8th grade English paper to court and not have things outlined is crazy to me. Not one timestamp, just gonna say all of them. So what, he's supposed to go find everything that you could possibly be talking about? This is crazy. And then they're gonna say you need a 2-day continuance when, like the judge said, you got this 2 days ago. So everybody is they keep arguing about Rule 106, and we know Rule 106, if you don't remember it, is the rule of completeness. So basically, it's to prevent evidence from being presented as misleading or be unfairly selective, right? So that's where the whole cherry picking thing comes in, right? So basically, they're saying if the state picks certain parts of the video interview transcript and present it to the jury, then the defense is trying to like basically make them piss off the jury by saying, for the rule of completeness, so they can see any and everything about Carmen, which in this case, Carmen will do or say whatever to save her own hide. So she's changing statements, she's fixing statements, she's swearing to things that was never an issue the day before. She'll swear to one thing today, swear it's red today and call it blue tomorrow. Whatever it takes to keep her own ass out of jail is what Carmen will do. So now they're saying, instead of being able to pick certain parts, put the entire thing in so that the jury can see Carmen flip-flopping like a fish out of water and see that basically she would do or say anything, and the shit that she's doing and saying does not line up with her testimony. And furthermore, what it does line up with is that the police were treating her a certain way, that they were offering her or implying certain things that she can get and keep herself out of trouble. And for lack of better words, it looks like they're leaning towards, look how she's living now. She's high as a giraffe's ass, but ain't had a dang on drug test in 2 years. So, excuse me, for lack of better words, you've known that Carmen Lauber was going to be this quote unquote star witness this entire time. You've known what Carmen Lauber was going to testify to the entire time. You knew exactly what she was going to say the entire time, down to what she said that was going to be corroborated by the dealer that don't deal in memory, Robert Crozier, the entire time. So 2 days ago was not the 2 days ago was not the first time you heard of it. It was not the first time it was going to end up in a situation. It was not going to be. And so putting 7.5 hours in to make sure they see everything you want them to see versus what the state is showing them is absolutely crazy. And now you want to go through 1,000 pages just so you can point out everywhere you want them to add more context. But then the crazy thing is they want to say play all of it for the jury, but then when they send a transcript back, they want the jury to only get pieces and parts of the transcript because we don't want them to read all of that. So you want them to hear it and just be pissed off that they sit here listen to this so that at some point they possibly zone out or don't pay attention to some shit they got to do with your client. Like, you're just really trying to piss them off, because if you want them to listen to the whole thing, why you don't want them to be able to read the whole thing? So you don't want them to have access to the whole thing on their own to make up their own mind or opinion about it, but you want them to sit through it. Like, no, you just want to piss off the state.
On the record in 231-500-139. Counsel for the state and for defendant are present. is present. Ms. Lewis, the defendant asked for a one-day continuance to allow time for defendant to, on the one hand, review the designations made by the state to determine whether there are some over designations that go beyond what should be published under 801D1B, and also to offer additional designations that in the defendant's view should be included under Rule 106. That request is granted. We need to come up with a set of deadlines by which defendant will take those positions in writing, by which the court and the state can review them, by which we can have a discussion on the record about which of defendant's positions are persuasive. And if possible, Mr. Bloodworth, and I know I don't have any control over this, I'd really like to build in time for the state's video editor to take whatever I decide and turn it into a video, so that when we're publishing a video, not just pages of a transcript. Let's work backwards from there.
Mm-hmm.
How long is that process? And if you need to take a moment, step out and tell your video editor to press pause, I'd understand.
So the state will, within an hour or two, maybe within 3 hours, have the video that corresponds to the status quo of the 6 exhibits.
Understood.
Now, depending on how much additional comes in and how much additional goes out.
Right.
Hard to say. 4 hours?
Okay. All right. As a practical matter, do you think we should start midday tomorrow or just come back on Thursday? I was hoping to come back midday tomorrow.
So we can do that, assuming was the court considering a deadline from defense something like 6 p.m. today?
Yes, something like that.
If we get that at 6 p.m., my sense is by 8:30 tomorrow, the state will have a response. The court rules by
9:30.
9:30. We can probably get the video done.
Okay. Ms. Lewis.
We're just discussing, I don't think we can get it done by 6.
I don't understand why. I mean, the transcript is only this much stuff printed in
Lady.
12-point font.
But
The Rule 106 designations would be immediately before or immediately after. And to the extent you're going to de-designating, you're just taking stuff out of those. So it's a relatively focused inquiry. You can go back and watch Carmen Lauber's entire direct and cross on court TV at 1.5 speed to refresh your recollection of what she said on the stand in order to determine whether this is consistent or not. To the extent you want to get more beyond this, I'm not sure you're entitled to do that.
I don't understand. what
Well,
you mean.
if, for example, there's 200 pages of interview with Jeff O'Driscoll the first time, and the state's just trying to put in 20 from the beginning, you don't get to skip to the end and say, well, these last 40 would be really helpful to us. We made a strategic choice not to ask Carmen Lauber about them when she was on the stand, but we'd like to put them in now. That's not this exercise.
I'm not sure I understand what you mean. The portions of the transcript that they pulled out are from portions of all 7 interviews.
I agree, but they're not, they're just portions that are prior consistent statements. And so it's, did they over designate? This goes beyond a prior consistent statement. Or is there some stuff immediately before or immediately after under Rule 106 that's required to qualify,
Jesus,
provide
it just
context
never
or display?
lands. It just never
Your Honor,
lands.
can I add a small wrinkle to that?
Sure.
In addition to prior consistent statement, it is rebuttal on recent motive to
Hey,
fabricate.
T. Lee.
Yeah, that is the same. That's both. That's the prior consistent statement rule.
Yeah, it's. I think there were 2 separate things in 802 D1, but maybe we're saying the same.
801 D1B.
I mean 801 D1. Yeah.
is consistent with the declarant's testimony and is offered to rebut. So
Right.
it's the same rule.
Okay, got it.
I don't see you doing prior inconsistent statements based upon a lack of memory.
Nothing in A.
I think we see it the same way.
Okay.
We have till 11 p.m.
No, I need
No,
I need time to read it. This is possible. I want to make sure that we have a common understanding of what you'd be permitted to do under 801 D1B and Rule 106. This is not an opportunity to recross Carmen Lauber. If you want to recall her, I'm not making any statement about that. But to the extent there was stuff you wanted to put in your cross that you didn't, you're stuck with that for now until you recross her. If, on the other hand, there is an over designation by the state under the bounds of 801 D1B, I need to know. And if, in defendant's view, there's a Rule 106 inclusion that's required before or after these designations, I need to know.
I don't think so. I think
Okay.
we are going to
So
be having
6
court
p.m.,
tomorrow
we need it in
afternoon.
writing, filed in the case, please.
Mm.
If you would separate out what you believe need to be de-designated versus what you need to be, I think needs to be added under Rule 106, I'd appreciate that. We'll reconvene at 8:30 tomorrow morning. Yes, Mr. Bloodworth?
Yes, sir.
Okay. Now, in terms of how to proceed for the remainder of today, do you want to put Contradimus on and get him done? Or do you want to break now?
Your Honor, if we can call him, he's 10 minutes.
Okay. Any objection, Ms. Lewis?
She said you ain't gonna give me till 11. She want to go now.
Time.
All right.
Oh, okay.
Well, it's only gonna be 10 minutes.
Yeah.
All right.
Okay. Got it. And then we'll invite the jury to come back at 1 p.m. tomorrow. Does that sound reasonable?
Yes, sir.
Okay. Very good. Anything else before we invite the jury in, Mr. Bloodworth?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay.
Okay, so T. Lee, I did see your information, and yes, we are turned off right now. I explained it earlier, but basically YT is at LawTube, and YSL kind of became an anomaly. So as of now, they want more analysis than court. They do not want us to just watch court in its entirety, despite the analysis and engagement that's going on throughout the trial. At first, it was a push to, hey, you need to be present, you need to be there, you need to be talking, there needs to be engagement in the chat, this, that, and the other throughout. And now that push has turned into, okay, don't just play all of it. Get you some graphs, get you some charts, get you play a clip, kind of like we do WTF. That's more so what YT wants to see versus the way that we do it. I know that the way that we do it is a little different from what's normally on here, but that's what it is right now, is what we're getting. Like I said, a couple of months ago, I heard that push to have more analysis and engagement, even with us having actual attorneys hopping on here and speaking. But it was, even with the constant engagement, the constant conversations in the chat, the constant discussion of each testimony, even with that, I think what they really want to say is you don't just get to watch together. So I guess it would be a little different if I were in there streaming, then we could probably get away with just watching court. But as far as us watching together, regardless of our conversation, analysis, discussion,
Ladies and gentlemen of the
predictions,
jury, I
all of that,
greatly appreciate your patience
they want
while we work through some
more
legal
of a
issues.
show and not
We will proceed with a witness from the
consistent
state,
lies.
and then I have some scheduling notes for you. Mr. Bloodworth.
They
Oh,
paused the
Mr. My
subscriptions. Once this back and forth is finalized, there may be a refund because they're going to take anything that I made from February, so they'll be able to refund you guys.
Please raise your right hand.
I know,
Do you solemnly
but
swear
it
that the
looks
testimony
like
you're about to give in the matter before
from the
court
back
will
and
be the
forth
truth,
that I'm
the whole
doing,
truth,
I'm
and nothing
trying,
but the truth,
guys. I
subject
can't
to the
say I'm
fees
going
and
to do
penalties of
the
perjury.
editing situation. That's just not what I do. I do my recaps, and so we watch together so I can do my recaps. So I'm gonna continue to do my recaps, but I do like watching with you guys. So that's not gonna stop me from watching with you guys.
It's Chris Kotrodimus, Kotrodimos.
Now, we brought you back to talk about a couple specific issues. We know from your prior testimony that when you reviewed data from Eric Richins' phone, specifically for February 14th, 2022, you looked at the Verizon call records.
Correct.
Those included text messages.
They did.
And that's the raw data that we talked about throughout your testimony.
Yes.
Is that right? And tell the jury, for an outgoing message from Eric Richins, how would Verizon list that time zone in their record, in their call record, that raw data?
It would depend on what type of message it was. For an SMS,
They don't want us
text,
to watch
which
the
is
whole
just a
thing.
normal type of text.
It seems like what I'm getting
It
from
would
it.
route it through their normal server. It would be in local time. For MMS, that message has to be routed through a server. And so they use the server to route that call. And it would have a timestamp for the location of the server, not necessarily the device.
So when you looked at those records, the outgoing messages for Eric Richins' phone in the Verizon records, what time was reported for an MMS outgoing from Eric Richins' phone?
So there was an outgoing in the record. There was an outgoing MMS at 12:23 p.m.
Would that be 12:23 p.m. in Utah?
No.
So what would the time of that outgoing message be for us in Utah?
We're 2 hours behind. So it would be 10:23 a.m.
Scott, if we could put up 3-14D, please. This was previously admitted in Mr. Kotrodimus' testimony. We can publish it to the jury.
Right, Amanda. There you go. Like the days we watch and they give us a little bit of court and then stop. And so we never really see the whole thing with all the analysis, the interruptions, and all of that.
We
Yeah,
entered this exhibit through your
exactly.
testimony last time, and we talked about this gap in activity from Eric Richins' phone. And so what you've just described conforms with the raw data. Is that right?
Yes.
And
Unless I go get a
describe it
rule
again now that the
22
jury can see
and
the
stream it
time frame we're
myself.
talking about. If a call record or a text message MMS showed outgoing from Eric Richins' phone at 12:23 in the raw data, you confirmed that that would have been 10:23 in Utah.
Correct.
How did you verify that?
So one, just the knowledge and experience of knowing that that's how Verizon routes MMS messages. They use an Eastern time zone, which is consistent with their headquarters location. So to verify that, for time zones are very critical for analysts, obviously. So what you would do is if you have a source to look at the original text, and in this case we do, which would be Eric Richins' his phone extraction, his cell download. I would expect to see, based on the time difference, an outgoing MMS text at 10:23 a.m. versus 12:23 p.m. And I did find that there was an outgoing message at 10:23 a.m., an MMS message to that number, and it was a photo.
So essentially, through your analysis and changing the time zones as necessary, this exhibit is still accurate.
Yes.
Scott, if you could put up 3-39D, page 5, please, for the witness. This has previously been admitted. And you can publish it as well. And you can blow up one of those messages or so now that we're talking about time zones, describe for the jury how we get to the times that are listed in all of these text bubbles. And so that the jury knows all of the messages that we have entered have these timestamps on them.
They do, yes.
And how do we get to the time that is on there?
Okay, time zone issue again. Okay, so phone extractions from software are provided, those readable files are provided in UTC 0. So to determine local time of when those
Can't play music
activity on the device happened
It ain't yours.
at the local time, you have to adjust. So Utah is -7 UTC during normal standard time. It is -6 UTC in daylight savings. So we just switched on Sunday. So now everything until November, when we switch back again, will be -6. So the -7 and the -6 denoted in these messages is a adjustment that is made by the software to denote local time versus software time.
So for each of the messages that the state submitted in this case, they have been adjusted to local time.
Yes.
Okay, those are all my questions.
Sure. Thanks.
Mr. Rollins? No questions. Okay. Sir, you can step down. Thank you.
Thank you, sir.
Counsel will proceed with the scheduling notes, correct?
Yes, Your Honor.
Ms. Lewis?
Yes.
All right. Ladies and gentlemen, I appreciate your patience this morning. We've been working very hard on some legal issues that will materially increase the efficiency of the presentation of evidence going forward. I know it's hard for you to know that, not being in the courtroom. I'm just asking you to take my word for it. We have more work in that regard to do. Rather than have you sit here while we do it, we're going to send you home for the day and not ask you to return until 1 p.m. tomorrow. So we will recess until 1 p.m. tomorrow. As always, during this period of recess, please do not speak about the case with anyone. Do not allow anyone to speak about it with you. Please do not watch, listen, or read anything about the case. Please do not do any research of any kind. I greatly appreciate your patience. Travel safely. 1 p.m. tomorrow. Please rise for the jury.
And watch PBS. So it looks like we are going to be done for the day. That's crazy. So 1 p.m. tomorrow, which would be what, noon?
All right, folks, have a seat. Mr. Bloodworth, anything else on the record today?
No, Your Honor.
Ms. Lewis? Ms. Nestor?
No, sir.
Mr. Rollins?
They're trying to get out of there now so they can go do what they got to do. before
8:30 tomorrow morning. Please travel safe. We'll be in recess. Thank you.
All right, guys. So it looks like the jury won't be in until 1 p.m. Looks like they'll come in at 8:30 in the morning. I guess the time frame as it stands is going to be the defense has until 6 p.m. to get in everything they want under Rule 106, where they want to add or take things out for completeness, relevance, admissibility in regards to all about 1,000 pages of these particular
solemnly swear or affirm that the evidence you're about to give.
Oh, that's that the guy with the 90-day fiance person. Oh, he's just saying, hey, Big Unk then came in here, y'all, in his snuggie. What was you doing?
I'm just checking, seeing how long the truck bed was. Dude just hit me back about that tote rack.
Oh, okay.
Goes for $200. He only want $100 for it. But wait and see if he said today, but I told him I ain't gonna do it today. Right, so we'll probably go grab it tomorrow. He just in Chandler. So.
Oh, okay. All right, guys. So it looks like the defense has till 6 p.m. today to go over those other 1,000 pages again, like they tried to say, which makes me feel like they never went through those pages. Why does it seem like this is up so far? And then, so they have to have this filed in the case in writing by 6 p.m. tonight. The state is supposed to respond by 8:30 in the morning, and then the judge is supposed to rule on these redactions or unredactions by 9:30 in the morning, in which case the final ruling will tell us what the state needs to put back in or take out further on their video that has to come in through Detective Driscoll. And so after the judge's ruling, they're supposed to take that to their video editor, take it out, put it in, everything that they're supposed to, double check it, and then we can go in front of the jury at 1 o'clock tomorrow. Yes, Big Unk is aware, and he just looked. He's like, so what do you do? So we had a conversation about it as far as he was like, he was here when I was going back and forth in this last portion that I submitted. So yes, I saw somebody say, well, what do they want us to do? Can we get a co-host? Can we play some music? Can we do this? And basically what they want is everything in the channel to be all me all the time with pieces of others. If that makes sense, is how they're doing it now. So instead of us watching court, even though it's all my commentary, all my engagement, all of my analysis or what have you, they want all me and pieces of others. And by others, that includes the case. So the only way to get around being able to watch court all day, every day is for me to go file a Rule 22, get into the pool and stream it to you guys myself and add my commentary, analysis, and engagement on top of that. Without it being all mine on the stream, then that they're trying to eliminate the entire trial, even though everybody is watching. So like I said, about 6 weeks ago, I became aware that the first set of information was like, more engagement, more commentary, more analysis. And then it was just like, well, that's happening the entire time. And then I heard other folks reached out and said, hey, did you get an email like this? And I hadn't got one, but I got one 3 days ago. So all memberships are paused. Anything that would benefit the channel has been paused. Like I said, we've been going back and forth, but I'm going to be very transparent. If the only way to do this is to go in and create a show or a situation where it's only pieces of court, I don't want to do that either, because I watch all of court so that I can do my recaps. So I can't piecemeal court, and I wouldn't want to piece out court because that's not what I do either. We talk about all of court and everything that happens in court, so I don't want to show clips. Our clips are more so for like WTF, but that's what they're looking for, more so like a WTF. I don't know if it's possible to get one from home and just stream it remotely. That I do not know. So I've been sent those Patreon, Discord, Twitch, a couple of other things. So again, I still watch the entire trial because that's how I do my recaps. And my recaps are what I originally started out doing. That's what I want to keep doing. And the recaps are my bread and butter. I do understand that what we were doing, the lives all the time, is not normally what you see here. So I get it. So I'm still going to watch court with you guys because I still got to watch court so I can do my recaps. So we'll figure it out. If there's a way that we can put something together where we can still, I guess, like satisfy those. What was that? But we can satisfy those, then we will. I can't commit to that right this moment, but I can commit to still watching trial. But I can't commit to doing that right this moment because, as we know, we got great news yesterday. A couple more things have hit my plate, and editing was, y'all have never seen me edit a damn thing. So putting things together, charts, graphs, all of those things have never been what I do. You know, I don't want to start that. I don't want to change it. I don't want to make it scripted. I don't want it recorded. I don't want to say think about it, but I don't want to think about it. That's just never been my angle, right? So I don't want to start doing that. But as for day 11, we have no more day 11. And as you can see, even with this happening 3 days ago, I'm still here. So we will still watch court together. We'll figure it out. Whatever I find to do or figure out to do, I will absolutely let you guys know. For everybody who sent me lunch and Pepsi and all of that today, thank you so very much. I'm getting ready to go tell Big Unc wherever he about to go for us, because we definitely about to use it. But all that Pepsi, we don't need all that Pepsi. We can get some water. No. I'm absolutely serious, Montresa. I've been going back and forth with them. I swear on everything holy that this is what was said and this is what was provided. That it's basically a repurpose of content or using someone else's content if it's the whole thing in its entirety. So they want it to be way more. I haven't got direct percentages, but they want it to be way more than the majority, to be all me and pieces of. So pretty much just think how we do WTF, where it's nothing but straight commentary, analysis, and us with pieces of with clips of court. That's more so what they're looking for when it comes to court, unless I'm directly streaming the trial myself. Got it. So that's what it is. That's what it's sounding like. I'm waiting for the final email to come back because, like I said, I've been sending my video. They have you do it like a video, like create a video and then post it with only the link. So that's kind of what it's been. So do I need to come out the bushes? Hey, so that's what we have. Right. I've been hearing that it's been happening or to a lot of people and they've been going back and forth. But to be honest, I'm not going to argue that hard for something I know. I want to do this. I can sit with y'all, watch the trial, talk about it, and then go do my recaps. But I can get my trial watching. So if there's a way to have a remote access to the trial, then I'll look into that. But to be honest, if it's not, we can still go live. So guys, don't feel bad. We can still go live. We're live today. We were live yesterday. We can still go live. I just think that they want their platform to say a certain way and other platforms to stay a certain way, and how we began to do it, and a lot of people began to do it again. YSL was an anomaly that changed a lot of things and spawned a lot of new things. Maybe they didn't think it would go this long. Maybe they didn't think it would happen this long. Maybe they didn't think some people would still be there or still be providing analysis, but we their platform, their rules, right? Friend. We will be back tomorrow again. a day behind, it's still the another entity stream. Y'all, I swear, there are a lot of big, I won't say what channels, but there are a lot of big channels out there who have reached down to our small little channel and said, hey, have you heard this? Have you seen this? This is what we're doing. This is what we're saying. This is what we're trying. I opted for information rather than saying everybody else is doing it, which I have heard other people do as an argument to say there's plenty of channels out here doing this. Why are you picking with me? But I don't know. I'm just saying, maybe we'll see. We'll see how this goes. We'll continue to watch trials as we would. I'm going to continue to do my recaps as I always would. And if it stands, we would be able to go back into it or reapply, I think in June or something like that. But then they have to scrub your channel again and see if they like what you've been posting. And if it's still more of the same, then they can say you're a no-go. I'm not going through and deleting all these videos either. So yeah, and you can't play music, anything that is copywritten. So yeah. But we'll come up with something, not today and not before I get all these other things on my plate. So we'll figure out how to juggle normal, what will be my new norm, and then we'll come back with what this could be. Not you gonna sing it. I might be here for it because Tiffany said, what, I need to make a video? Tiffany told me she gonna make a channel. I hollered. Pure comedy. So we will figure it out. I'll look into some other things. Like I said, I've been sent Patreon and what else did I have? I have Discord. I think it was something else, but I think I just used Discord for meetings during YSL. So we'll see. Yes, we can watch motions tomorrow at 8:30 in the morning. We definitely can if they are going to have them up. So I'll be up in the morning. I'll have the stream initially set for 8:30 so we can look at these motions. But I imagine the only thing about that is they're going to have to cut. So we may not. Because they're going to have to cut and go make the video. And that video, he says, is going to take about 2 to 3 hours. So we may not. I'm going to watch motions, but we may not. We can go to Google Meet or Zoom. Hey. Listen. So yes, if the end all be all is they don't like the way that I do what we're doing, then it should, because I did ask about refunds for you guys. It should provide refunds. If it does not, then you can request a refund. And if you request a refund, they'll just take it from whatever they were going to give me for February, because with this being on pause, I lose all of February as well as part of the terms. And I want my refund. Yeah, they're going to take it out of that. And I'm not going to get it anyway. So it is what it is. Tambourine toes. Listen. All right, guys. So we are at this point off until 1 p.m. Mountain. So that's 3 p.m. Eastern that will be off till. And that's the thing. It gets me through my days too. So I'm still going to watch trial. So don't think that I'm going to do that. That's never been our channel. It's never been based on coins. That's why I tell everybody, keep getting their coins. We just getting our coins. You got an email this morning? Okay. Yeah, they should possibly send that back. Or should not possibly, they will. So we're good until oh, thank you. Super chats was up. Right. But hey, not my business. Not my business. It is what they say it is. All right, y'all. I will see y'all tomorrow at 1 p.m. If we do hop on at 8:30 in the morning, I'll make a separate live and we'll just hop on. And it'll be separate from our actual day 12 live. So we'll just have a live that pops up, but I'll make sure I do it because it has to be up before like at least 30 minutes before for everybody to get the notification. So we'll have day 12 set for 1 p.m. If there's going to be some argument during 8, matter of fact, it will be a second one up. It'll just be a random one. Just go live real quick. Again, Big Mad, you put my money where I say. Listen, again, we'll be here watching court. And if we need to move it somewhere else, we can. But for right now, I'm not in a rush and I'm going to finish this trial and we're going to do the next trial and whatever else after that. But I'll see y'all tomorrow. Day 12 official live will be at 1 p.m. Mountain or 3 p.m. Eastern. And then we'll just pop on in the morning to see what the judge's ruling ends up being. And I wonder if I should check online to see if they make that 6 p.m. deadline. All right, y'all. I will see y'all tomorrow.